May I pray, your Lordship? Lordship, item number 8 and 9, Lordship, we need some time to file our affidavit, Lordship. Can it be on the 26th, Lordship, of this month?
Your body,
For the appellant, Lordship, in item number 8.
then it goes to beyond applications. Then counsel for the appellant. Writ appellant prays for and is granted 4 weeks time to file affidavit on behalf of the appellants.
Lordship,
List after summer break.
obliged, Lordship.
Please, your Lordship.
Yes.
Lordship, actually, what happened, my lord? Item number 15, my lord. It is conducted by Mrs. J.D. Count, my lord. I am not on record, my lord. I have been just requested by her yesterday, my lord. She is in Mumbai for her daughter's treatment, my lord. Take an adjournment, my lord. Or her
It is
request I'm
stated that
adhering, my lord.
lead counsel, Mrs. J.D. Count, is not in town and is engaged in some personal difficulty. List after 4 weeks as prayed.
Highly obliged.
May I please, your Lordship? Your Lordship, I'd beg to mention item number 22 as the arguing counsel for the petitioner, Mr. R. Hazarika, is in hospital, your Lordship, because his wife had a surgery
It's
yesterday.
stated that arguing counsel, Mr. R. Hazarika, is not able to come because of personal difficulty, not able to attend the court because of personal difficulty. List up to 4 weeks.
Much obliged, your Lordship.
Yes.
Daily list for orders item 1.
Please, your Lordship.
Yes.
Lordship, we have filed an affidavit objecting to the delay of 300 days. Lordship, the delay has not been explained. Lordship, my objection may be recorded.
Oh, yes. Yes. You received the objection.
Yes, ma'am.
All right, now respond. Let's see how you explain the delay.
Yes, the conversion petition delay for 300 days.
Yes. Read, please. What is your explanation? Yes.
In this case, the affected persons are all dismissed.
Or
Legal and employed.
rustic. Merely, can that be the reason?
Yeah.
Let's see. Let's see what you have mentioned.
The reason that these poor workers took some time to take decision about their thing. I have explained in my petition 4 and 5.
Hardly anything explained, sir. What's there on merits? All right. Let's know what is there in merits.
Then it is I mean, on dismissal order, dismissal case, the London Labour Court has passed an ex parte order.
Ex parte award.
Ex parte order.
Why?
Ex parte order was done because the advocate engaged by the workmen expired suddenly. And they expired.
Mhm.
And thereafter they engaged one another advocate,
Yes.
but he did not attend the court.
He did not
Did not
attend.
without any-
That can't be a ground. That can't be a ground.
And thereafter on the workmen were not informed regarding absence of their advocate.
Mm.
And without any notice to the workman side, the Land Labour Court passed the ex parte order.
Notice, the matter was received on reference. The workmen were supposed to prosecute it.
Yes, my lord.
Then, if
engaged
they don't appear, what the labor court is to do?
after the expiry of the advocate, my lord.
You yourself say that another lawyer was engaged.
Yes.
Then the expiry of the lawyer has nothing to do with the ex parte proceedings.
Another were engaged, but he did not appear in the court, my lord.
Then have you filed any application against the lawyer in the bar council for not representing the case?
No.
These are flimsy excuses. Let's see the award. Where's the award? Where's the judgment of the red court? Let's see first.
Is 118.
It was a contested in the writ petition. Where is that argument that you are not represented? Let's see in the writ court where that argument was raised.
Actually, this, I mean, some service, this service for the trade non-victimization.
Little louder, sir.
It was, they were victimized for their trade non-activities.
Whatever. Where is that argument in the single court that the lawyer did not appear?
Yes, we have raised that matter. We have raised that matter. before the
Let's see, read. Read where there is argument. There are only two arguments, acquittal and giving of evidence by the manager and acceptance of the inquiry report by the same manager. These are the only two arguments in the writ court.
In this case, what happened, my lord, the manager filed an lodged an FIR against the workman.
Sir, you advanced one argument saying that the lawyer did not appear and so you could not represent the case.
Yes.
So where is that argument? Have you said so in the writ petition?
Yes, yes. Certainly.
What is the name of the lawyer? Have you mentioned it? That such and such lawyer was engaged?
We have mentioned.
Let's see. Ground. Para 23.
Page 9.
Yes.
Para 18. Para 18, page 9.
Yes.
That's a BN Sharma advocate expert on.
We read that. We read that. Where is your complaint against Kanayalal Gupta?
No, I have not.
Well, then we will not accept this. Your delay has not been explained, sir. Not in the least.
The poor often belong that actually basically because of their poorness, financial constraint, they could not file appeal in a.
No, we can't have this kind of sympathy on all counts. Supposing we condone the delay taking some lenient view, but the fact remains that even in the labor court, there was no representation, so the witnesses were not cross-examined. What will happen now? What will happen?
Our prayer before this single judge was to remain back the matter to the labor court so that we get a opportunity.
The poor workmen, at least let them have the opportunity.
Whatever it is.
All right, we'll condone the delay and then we'll hear your merits. Delay control application allowed.
Copy may be so. Copy may be so.
Writ appeal to be numbered and listed for admission after 2 weeks.
Lordship may direct them to give us.
Copy of the writ appeal be provided to learned counsel representing the respondents.
Item number 224.
Lies, Lordship.
May it please your lordship.
Yes, please.
I am in item number 3. There are 3 cases tagged together. 2,
Yes.
3, and 4.
Hmm.
2 is the contempt petition and 4 is the private
Right appeal.
respondent who. Yes.
Yes.
So I am for the state's appeal. So if lordship is pleased to take up my matter.
Yes, definitely. Please argue.
Yes, lordship will have to take
Let's have the right appeal, please.
item 2.
Yes. No, item
If
3.
lordship,
Item 3, Mr. Saikya.
item 3, I'm sorry. Yes,
Yes.
item 3. Yes, item 3.
Yes. Yes.
So lordship will kindly take the Assam Panchayat Act because on a very narrow campus, my appeal is stationed. Section 72 and 73 will be very relevant. So before
just a
placing my, yes, Lord.
Assam Panchayat Act, section 72.
72 and 73, I would like to place.
Yes. What do you want to point out, please?
Yeah, point out 72 says what is the procedure for filing a resignation or tendering a resignation. Resignation or removal of the president and vice president. A member holding the office of president of the Jilla Parishad may resign his office at any time by writing and send it to government through the deputy commissioner. Lordship will kindly mark to the government through the deputy commissioner, and the vice president of the Jilla Parishad may resign his office at any point of any time by writing and send it to the president of Jilla Parishad, and the commissioner, and the office shall become vacant and the expiry of 15 days from the date of such resignation, unless within the said period of 15 days he withdraws such resignation by writing and send it to government in respect of the president and to the president in respect of the vice president, as the case may be. So while tendering his resignation, lordship, in my humble submission, he will have to send it to the government through the deputy commissioner. But at the time of withdraw, if he wants to withdraw it within a
It is
period of
directly
15
to the government.
directly to the government without any interference of the deputy commissioner.
Yes.
And 73 is regarding the no confidence motion. In our case, a few members have filed a notice on 26th of August 2021 seeking no confidence against the president. So on the basis of that, lordship, a meeting was called for on 28th of September. If lordship is pleased to take up that later, in the writ appeal page 114.
114.
114. Or lordship will kindly come to page 115.
Yes.
To the president Jilla Parishad notice regarding no confidence, it was signed by 9 members. And on the basis of this, there is a date fixed on 28th of September. Lordship will kindly come to page 120. In pursuance of the deputy commissioner's letter dated 6 September and under section 173(2) of the Panchayat Act, a special meeting of the Karimganj Jilla Parishad will be held on 29/2021 at 11 AM in the conference hall of deputy commissioner to discuss and finalize the no confidence motion against Sri Ashish Nath so and so. So just before 2 days, he tendered his resignation.
All right.
That resignation, lordship will find at page 39. Annexer 1 of the writ petition.
Yes.
On 18 September 2021, resignation from the post of president. With due respect and humble submission, I would like to inform you that for my personal problem, I resigned from the post of Karimganj Jilla Parishad. So according to the law, it will remain like this for next 15 days.
15 days it remains alive. And then it is acted upon.
And when the vacancy, it will continue from the date of expiry of 15 days.
15 days.
Yes. Now, what he had done, he had submitted an email to the deputy commissioner
on
2nd October.
Before expiry of 15 days.
Before expiry of the thing, but that is that Lordship will find what he had done. Yes, Lordship will kindly come to page 45.
What about page 44?
Page 45, I'll come little bit later.
Okay.
44.
Ms. Saikia, you are trying to convince us that the resignation withdrawal was submitted to the deputy commissioner, but
On
we have
second.
come across come across this annexure 4 at page 44.
Yes,
is to the
that is what
government.
I'm coming. Just 1 second, Lordship will kindly see.
All right.
Second, page 45 for a moment.
Yes.
2nd October, withdrawal of the resignation by Ashish Nath on 2nd, and it was addressed to Deputy Commissioner.
Okay.
Now, Lordship will come to the previous page.
Mm.
It is of 1st September, 1st October.
Mm.
Lordship will kindly see the reference number. Resignation letter of 8/18/9 and
Yes.
communication so and so 18/9. There is no reference of 1st October's email or letter, whatever. So this is a document.
1st October's what? This is by itself is dated 1st October. This by itself is dated 1st October.
1st October, whether he had submitted it or not, that is the question.
So that's a different argument. What about reference number? What you were trying to say? We could not get
Yes.
it. What you want?
Yes, Lordship. Now, what is happening here? On 1st, he submitted the letter to the, according to him, he wrote to the government. Lordship will
Yes.
kindly see principal.
Hmm.
Principal Secretary, Government of Assam, Panchayat and Rural Development.
Yes.
On previous date, page 45, he wrote it to the Deputy Commissioner on 2nd.
Not previous date. That is a subsequent date. That is a subsequent. This is 1st
That is a
October. That is 2nd October. Yes.
Yes, yes, my humble submission is very clear. This is the main crux of the whole case. He wrote it to
Your
the
argument
Deputy
is that
Commissioner.
there is no reference to the letter of 1st October in the letter of 2nd October.
No, my
Then-
case is totally different. My
Then-
case is that he wrote this letter of 1st October and came to dispute and submitted it on 8th of October. He passed that for 15 days time.
Okay.
That is
How do
the
you say
case.
so? How do you say
How
so?
do I say? Here, suppose he has written a letter on 1st October.
Hmm.
There is no requirement for him to submit a letter to the Deputy Commissioner on 2nd.
Hmm.
Why he is submitting 2 resignation letters?
Right.
If he had submitted it on 2nd,
Hmm.
that he had uploaded in the Panchayat and Rural Development Department's website also, which
Hmm.
the 2nd was October, 2nd was Gandhi Jayanti, and 3rd was a Sunday. So we received it on 4th.
Hmm.
We received it on 4th. We have come to know that this was not properly done because he had to write and send it to the government, not to the Deputy Commissioner.
Is this your reply? Is this your case in your affidavit in writ petition?
This is absolutely our case in our affidavit.
Let's see. Where
Yes,
do you
Lord.
mention
Yes.
so?
Yes, Lordship will kindly come to the affidavit at page 95.
Hmm.
Lordship will kindly come to paragraph 6, 7, and 8.
Thank you.
Yes.
May I read it, Lordship? These
Hmm.
3 paragraphs will clarify the whole picture. Regarding the statements made in paragraph 3 of your petition, your humble deponent begs to state that the department had received a resignation letter dated 18/9 of the petitioner resigning from the post of on 8/10/2010.
You are talking
Accordingly,
of the resignation letter.
That also and the subsequent letter also.
Okay.
Accordingly, the matter was processed with the approval of the Honorable Minister. The resignation of the petitioner from the post of Karimganj Jilla Parishad was accepted, and the same has also communicated on 11/10/2021 by the office of your deponent to the Deputy Commissioner Karimganj, along with the
Okay.
copies of the Commissioner Panchayat and Rural Development, Chief Executive Officer, Jilla Parishad, etc.
Hmm.
7. The deponent begs to state that office of your deponent received the withdrawal of the resignation letter
I told him
1/10/2021.
that this should be the argument. Page 99. Oh, yes.
received the withdrawal of resignation letter of 1/10/2021 from the petitioner by DY number so and so on 8/10/2021. That is after the expiry of the stipulated 15 days period as prescribed under the provision of section 72(1).
Okay, okay, very well. Now let's see how the learned single judge deals with this issue.
Learned single judge has not dealt with this. Her learned single judge has dealt with the letter of second.
There was
I'll
no
come to-
argument. Was there any argument made that
Yes, argument was made.
withdrawal to the deputy commissioner is of no worth whatsoever? Where is that
Absolutely,
argument?
Lordship. That has been ignored by the learned single judge.
Let's see the argument, how it has been dealt with.
Lordship will kindly come to paragraph 19, page 151.
181 nahi hoga ji.
151.
151.
151.
150. Yes.
Paragraph 19.1.
19 point.
He has sent it through email also.
That email is of that the other one, the 2nd October's letter. 2nd October's letter to the deputy commissioner.
That email, he says, para 19, read please. The 2nd October letter has been sent to the Panchayat and Rural Department, Government of Assam.
It has to be addressed to the government, Lordship. It has not to be addressed to the deputy.
Address doesn't make any difference. The letter has been, if he had addressed it to the Chief Minister of Assam, how would it make any difference? It has been received in your department, that you can't dispute. If you have admitted the fact that you have received the mail has been received on 2nd.
Yes. Now Lordship will kindly come to section 72.
Yes.
Last 3 lines.
Mode of addressing would not matter much.
No.
Yes.
No, Lordship.
Yes.
The
72.
date of 72.
Just hold on. Yes. Yes.
Such resignation, unless within the period of say 15 days, he withdraws such resignation by writing and send it to the government.
Send it to the government. So
Writing,
to whom it is to be addressed?
Writing to the government.
Mail is to be considered as writing. We can't now, in this age, we can't take this restrictive or absolutely redundant view that sending it by mail is not sending it by in writing. That we will not accept. That argument we will not accept, sir. Plain and simple. Now you are not living in the Stone Age. Any communication by mail is a communication. Let's first, Mr. Saikia, let's appreciate this argument. Can you cite a single judgment which says that communication by mail will not be considered to be a communication?
No, it is not. We are accepting it. We are accepting whatever is sent in the mail. It is to the deputy commissioner, addressed to the deputy commissioner.
Oh, Mr. Saikia, please read para 19. Email account PNR dispur@gmail.com.
That is okay, Lordship. The thing is that whom it has to be addressed. If I have to sign a resignation,
it has to be sent. No. You see, if you are on that hyper technical argument, read your 72. It doesn't say that to whom it is to be addressed. It just says send it to the government. Send it to the government.
Write it to the government and send it to the government.
No. Address it to whom? If it is all right, if it is to, then you will, next argument will be addressing it to the secretary is not addressing it to the government. That is too hyper-technical approach, sir.
No, it is not hyper-technical. We have Assam Rules of Executive Business 1968, where we have said who are the officers who represent the government and who are the officers who do not represent the government.
Oh, all right. Okay. Very well. Yes.
So now, what is their understanding? Their understanding also same. Page 131 in their reply.
131. 131?
31.
Yes. Yes.
Now, Lordship, for counter argument, Lordship, if it is to be done to the deputy commissioner, and according to Lordship, that deputy commissioner is a government. For the time being,
he is one of the wings of the government. Yes.
He is not the wings of the government. He is one of the instrumentality of the government. No doubt about that.
Instrumentality of the government. Yes.
Yes, Lordship. But he is not the government. Government has, he is the executing authority of the government.
All right. Okay.
Now, when we say that he has sent and submitted, till date, he has not said when it was sent. It was submitted on 8th.
Mhm.
So first he have to say that I have submitted the letter dated 1st of October 2021. Where?
Then Ms. Saikia, then we come to that interpretation. What do you mean by send? Does it require action only on the part of the sender, or further proof of delivery is to be given? There are
Here
n
the
number of
delivery-
judgments.
Here
N number
the
of
delivery
judgments.
is not required. It is once it has been sent,
Yes.
on which date it was sent. That is the critical issue.
All
But
right.
if Lordship
Yes.
holds that 2nd October's email is sufficient, Deputy Commissioner's letter is sufficient, then I have no arguments to make. But if you look at
That
the
is
true
prima
spirit-
facie. That is the prima facie. That appears to us prima facie. We are ready to listen to you. You convince us that addressing it to the wrong authority, but sending it to the proper authority would not be the compliance of law. You please satisfy us on that. If you have
My
any
thought-
judgment, because we know of dozen judgments of Supreme Court that the label of a petition is immaterial. What is relevant is the contents. That there are
Absolutely, Lordship.
n number of judgments of Supreme Court on that aspect. Even if you cite a wrong provision of law, that does not mean that the contents have to be ignored.
That argument the other day I made regarding that constitutional matter, APSC's matter.
Yes.
That wrong citing, say,
Wrong quoting, yes, wrong quoting of wrong
or
provision is,
non-quoting also.
yes,
Even
yes.
if I don't quote also.
That
also will not
celebrated
make
judgment
any
of Madhulimay,
Yeah,
wherein
absolutely,
the Supreme Court says label of a petition is immaterial. So that is prima facie our view. If we are ready to listen to you, you satisfy us on that aspect.
Then
If you have any
Lordship
judgment, yes.
If you Lordship want few judgments on this, then Lordship will kindly give me some time. I'll satisfy this.
Whenever
Because-
you,
Let it be on 17th or 18th.
very well. Okay. After arguing the matter for some time through VC, Learned Advocate General submits that some more time may be allowed to address the court on the legal issues arising in this writ appeal. List on which date you want? Tell us a convenient date, please.
Let it be on 22nd, Lordship, if it is
22nd.
convenient to down 22nd.
Yes, 22nd. What about the contempt?
Contempt may not take up. Lordship may take up the contempt.
What has happened? Your client is now holding the post.
No, my lord, they have not allowed, despite, my lord, the presence of the Deputy Commissioner. And I have made a categorical statement that the executive officer, my lord, and the Deputy Commissioner is not allowing, my lord, to enter into the office or to.
Where is the
my lord.
statement? You have
Yes,
you have
yes,
filed
my
some.
Yes, my lord, in the contempt application, your lordship will take up.
But that doesn't mean that you are not required to comply with the order, sir.
Lordship, so far as the
Then again, we are compelled to call your secretary now, then we'll keep your principal secretary. If you are on that stand, that because we gave our indication that we like to hear the appeal, that doesn't give you a handle not to comply with the order.
we are ready for the contempt.
Ready for what?
For a contempt case, Lordship, this thing.
All right, argue then.
My lord will kindly come to para 7 of the contempt, my lord. It is respectfully, lordship has got
There are 7 of what?
of my contempt application.
Hmm. Has he been given the charge or not?
My lord, in my humble submission, my lord, if I may most humbly draw your lordship's attention to the affidavit which has been filed by the Deputy Commissioner on the 11th of May.
Simple question. Whether he has been given the charge or not.
In my humble submission, my lord, there's no provision in the act which enables the Deputy Commissioner to hand over the charge.
Okay, then is he being allowed in the office or not?
My lord, he himself has sent 2 letters on 20th of August
Okay, then we'll
2020.
direct your principal secretary to remain here and then escort him to the office so that he can assume the charge. You want us to do that? If you're standing on those ceremonies, we can take care of the things.
My lord, I
By tomorrow morning, we shall have a report that he has been allowed to join the office. We will not allow this court's orders to be flouted, even for a second.
My lord, may I most humbly draw your lordship's attention to the order, my lord, page 38 of the contempt application. My lord.
Yes.
Paragraph 23.
Yes.
line number 5 from top of that paragraph, it is therefore directed that the jurisdictional deputy commissioner, that is the deputy commissioner Karimganj, shall convene and hold a special meeting to discuss the motion of no confidence by serving requisite notices upon all the stakeholders, including the petitioner, to attend the special meeting and by fixing the date time. Malab, this in my humble submission, he has done, Malab.
Without the petitioner being in the office. He has not done it. He has postponed it.
Malab, there is a letter, Malab, by himself, by the petitioner, that he has assumed office.
Where
Malab,
is it?
kindly,
Where
Malab,
is
kindly
it?
see pages 59 and 60 of the counter affidavit, Malab.
Yes. 59.
59 and 60, Malab.
Assuming office and allowing the elect
I assume the charge of
to the
chair.
office. That is an assumption. But physically, whether he is being allowed or not.
That
All right, we direct your principal secretary to ensure that the order is complied with in letter and spirit. And if it has not been, the concerned officers, they shall be proceeded departmentally. You want us to give that direction? We are trying to play a game of hide and seek.
no, Malab.
We can ensure that the order is complied.
Not at all, Malab. That
2 o'clock, the report should come here.
Deeply obliged.
Don't try to play with the game, play games with the court. Advise your officers accordingly.
Lordship, in that case, Lordship, I have one more submission to make, Lordship.
Yes.
I have also filed one appeal, Lordship. In the
You argue on merits.
One, I was there, Lordship, for staying the operation of.
All right, argue on IA. We'll decide it right now.
In that case, Lordship, one status quo order was passed by this notice. And the contempt petition was filed subsequent to the passing of the status quo.
Yes. Status quo on what? Status quo, he has assumed charge on the very day. The effect and operation of the order has not been stayed. Again, Mr. You also take note, Mr. Counsel.
Lordship, on that day also, other side was present, Lordship. It was in the presence of both the parties, Lordship. That is
Immaterial, sir. Status quo doesn't mean that the effect of the order is wiped out.
No, that is not there, Lordship. That is why I'm not submitting also. What I am submitting, Lordship, as on date, Lordship.
Status quo would mean that he continues to hold. The order of this court is deemed to be in charge of the office.
Lordship, against that order, Lordship, no vacating has still now been filed, Lordship. He has.
Mr. Nayak, read the order of the single judge, please. Status quo rather affirms the direction given.
Exactly.
The direction is deemed to be in charge of the office.
Lordship, when that.
All right, keep your principal secretary present tomorrow. We are so more to taking cognizance.
Deeply obliged.
You want us to do that? Are you sure?
I'm referring to the.
Your Lordship, I am appealing for the department.
All right, you argue on that status quo order. We'll clarify what the effect is. Okay.
Is still there, Lord.
Yes, we'll clarify what does that mean. We'll clarify it. Give it. Let us see that order. Yes, Mr. Nayak.
Your Lordship,
Your appeal is in number?
Item number.
Item number 4. All right. Yes. Let's see that appeal. And what the respondents in your opinion, Mr. Nayak?
Lordship, I'm appearing for the private respondent in the writ petition, Lordship.
Status quo is in which order, which appeal?
Status quo is in my appeal, Lordship, the state's appeal.
All right, yes.
I would like to just apprise this honorable court only
Yes.
one thing.
Yes, yes. Definitely.
When this status order was
States
passed,
appeal,
Lordship,
states appeal. Just a minute. Let's have the appeal first. Status quo order is
it is passed in my order, in my case, Lordship.
date, please.
8/9/2020, Lord. 8/9/2020.
आइए आइए 2764
Yes.
Status quo be maintained, yes. Okay,
Yes, Lordship.
yes.
In what circumstances this status quo was passed, Lordship? I just like to apprise whether Lordship accept it or not, that is up to the honorable
Yes,
court.
please tell us.
When this appeal was filed within 15 days of the passing of the order, Lordship, the honorable court, after hearing our side, Lordship, was pleased to pass an order. At that time, the other side was on caveat, they also appeared. Court put a direct question to everybody, who is now continuing. From our side, we said that the private respondent was continuing. The person who has filed the contempt, he was also present in presence of all.
Mr. Advocate General, this question.
Lordship will kindly hear for another 30 seconds. That's after I will not make a single word also.
All right, all right.
So at that point of time, the court said that whoever is continuing, let him continue. We are fixing the matter at the earliest. By that time, the record should be produced within 10 days. The matter will be disposed of. That was the situation when status quo order was passed.
Yes.
That is my period. I won't speak a single word further.
All right, okay. Now,
So
raise
it
your
was passed
application.
in presence of everybody. The private respondent, the contempt petitioner, all were present at that point of time. They also knew that they are not continuing. The private respondent was continuing. This was the situation.
Yes. Anything else to say?
Now, from my side, okay, Lordship, may I take leave?
All right.
My lord will take note of one aspect of the matter. The honorable single judge, while allowing the writ petition, was pleased to set aside the order, handing over charge, my lord, to the private respondent. So how come, my lord?
Read that,
Yes,
read that.
my lord, para 20.
Yes.
The upshot of the above discussion is that in view of the sending of the letter of withdrawal of resignation by the petitioner within the period prescribed of time as stipulated in section 72(1) of the Assam Panchayat Act, the office of the president of
Mr. Nayak, do you want us to make comment on your conduct of your officials?
No, lord.
Are you serious enough? You read para 20, it's very clear, deemed to have continued as the holder of the office of the president.
Lordship, at the time of when the learned single just passed the order, Lordship, I was holding the post of president, Lordship. Lordship, am I not entitled to?
It is a deemed order, deemed to have continued as the holder. It puts the clock back in time.
Lordship, at that point.
Okay, very well. Okay, then we take suo moto contempt proceedings against your secretary.
Lordship, am I not entitled to be aggrieved, Lordship?
So you argue on merits. Who stops you? We are here now today to decide the appeal. Argue.
That is why, Lordship, your Lordship on last day said, okay.
So we had started the hearing, Mr. Nayak.
No,
we are ready to complete it right now. We gave out our mind. That is the only difficulty.
No,
we should have kept silent. This is simply a game of hide and seek.
I humbly submit, Lordship. That is
we are making it now. We are making an interpretation of these orders. What would it mean? Okay, take down. Learned Counsel, Mr. So-and-so, as representing the petitioner in contempt number so-and-so, contempt case number 793/22, urged that in spite of pertinent direction given by the learned single judge in para 20 of the writ petition, within bracket reproduced here in below supra, for the sake of infra, for the sake of ready reference, comma, his client is not being allowed to work as the president of the Zilla Parishad, and on the contrary, comma, the proceedings in the writ appeal filed by the state are not being concluded. He further submits that as the learned single judge categorically held that pursuant to the questioning of the order whereby withdrawal of the resignation of the petitioner was accepted, the petitioner is deemed to have continued as the holder of the office of the President Karimganj Jila Parishad, comma, the status quo order passed by this court in IAS civil number 2764/22 in writ appeal number 291/22 would rather fortify the case of the appellant and affirm the direction given by the learned single judge that the petitioner should be allowed to continue as the president. He urges that the respondents are trying to play a game of hide and seek, and in this manner, comma, the petitioner is being illegally deprived of the right to continue as the president of the Zilla Parishad. Full stop. Mr. Nayak, you represent the private respondent?
Yes.
Appearing for the private respondent in
Contempt. Contempt.
In contempt, it is 4, my lord.
just hold on. Where is writ appeal number?
I'm appealing in the second item number 4, Lord.
And that's what we are asking you. You are on the panel of the state or what?
No, Lord, I'm appealing for the private.
No, that's all right.
Yeah.
We are asking you in the other context that you are on the panel of state or designatedly you are for the finance department.
I'm the standing counsel of finance department. I'm not a counsel.
Okay. Representing क्या लिखा last one? Appellant in writ appeal number 289/2022 urged that as the order passed by the learned single judge has been stayed by this court in IA number 2764/22, comma, his client is entitled to reap the benefits thereof and is justified in continuing on the post of president. We have given our thoughtful consideration to the submissions advanced at bar and have gone through the material available on record. A perusal of the observations made by learned single judge in para 20 of the order dated so and so refused supra would clearly indicate that the resignation letter offered by the petitioner was deemed to have been withdrawn within the timeline stipulated in section 72(1) of the Assam Panchayat Act, and as a consequence, comma, it was further directed that the petitioner would be deemed to have continued as the holder of the office of President Karimganj Zilla Parishad, notwithstanding the letter of resignation dated 18/9/2021. Full stop. The said order could have been effect and operation of the said order could only have been kept in abeyance had there been a stay on the operation thereof. Full stop. The order of status quo passed in IA number so and so would rather indicate that the direction given by the learned single judge has been reaffirmed. Thus, comma, we hereby direct that the petitioner in contempt case number so and so shall forthwith be, comma, permitted to hold the office of President so and so Zilla Parishad, Karimganj. The compliance report will be placed for court's consideration tomorrow.
Deeply obliged.
You get an order of operation stay, and yes, we are happy. The status quo in such circumstances, absolutely unacceptable. Tomorrow, yes. Oh, let that go. Let that file be tagged, but that will come on 22nd. It need not be listed tomorrow.
Item number 5,
May it please your lordship. Well, in terms of the last order for implement, my lord, the newly implemented respondent number 8, my lord.
Yes,
Well, newly implemented respondent, my lord, notice is required to be sent, my lord. So may I pray, well, notice may be issued.
you have impleted
Yes.
by filing an amended cause title.
Yes, my lord.
Amended cause title has been filed
Yes.
in terms, where is it? Page,
In terms of the order 19.5, my lord.
you've done it by hand or what?
I have supplied copy to the section and they have also done it in their.
Newly implemented respondent numbers 8, Deputy Secretary to the Government of Assam, Hill Area Department.
Yes.
Let notice be issued to the respondent number 8.
Well, I appear for it.
Mr. Nath appears on his behalf.
Lordship,
Will you like to file something on behalf?
yes, well, I need some.
He
time
prays
to
for and is
check
granted 4 weeks time to file
Lordship.
affidavit on behalf of such respondent.
Lordship.
Obligation.
Item number 6,
We got the copy of the condemnation petition. I would like to file some objections. Your lordship may provide some time. Objection to the condemnation petition.
They have filed.
No, we'll be filing it. We have received.
You want time,
Yes.
Mr. Das appearing for the respondent,
Yes, ma'am.
Water Resources Department,
No, my lord, is the private response.
Private.
private respondent,
I am for the appellant.
prays for and is granted 4 weeks time. 4 weeks time. Why?
My lord,
4 weeks, 2 weeks will do, man.
2 weeks time, so as to file an objection in the application seeking condonation of delay. List up to 2 weeks.
obliged.
item number 7,
Wait, please, your lordship. My lord, there is delay of 44 days in filing the accompanying application. Read appeal, my lord. Notice has not been issued, my lord.
You are appearing, sir?
I'm for respondent number 1, Union of India.
Uh,
response.
issue notice to the respondents. Mr. So and so, Standing Council Union of India appears on behalf of the respondent number 1.
1.
Thus, on steps being taken, steps for service on remaining respondents be taken within 3 days, whereupon process be issued to them. Rule is made returnable in 4 weeks.
Obliged, lordship.
item number 10,
Wait, please, my lords. This is the eviction matter.
Eviction.
Uh,
Yes, please.
Yes, my lords.
Carry
So,
on.
My lords, there are 2 to 3 important issues that remain in this particular petition. I would like to point it out.
Silsako bill. Yes.
One, my lords, that can the court allow a retrospective application of a prospective legislation? That's the first issue, my lords. Second legal issue that remains is, can requirement of a service of notice be done away with when right to life is being taken away by the state of the appellant? And the third issue that remains, my lords, is wouldn't a rule of estoppel or a doctrine of legitimate expectation apply when the state has recognized long physical existence of the appellant on the land through several means? My lords, I may just take your lordship's attention to the impugned order.
Yes.
On
please.
page 82, my lords.
Para.
Para 39, my lords.
When is the question of encroachments leading to virtual extinction of a water body,
My lords.
probably these technicalities would not come in the way.
My lords,
That is our prima facie view.
my
You
lords,
want to dislodge that opinion, right?
my lords, I understand what's falling from the court.
Yes.
There are two arguments that I have on that.
Yes.
The utilitarian argument that has been raised by the state that this is for the larger benefit, that has two answers.
This is the right of the lake to survive.
My lords, that has two answers.
Lake is also a living body.
My lords,
Yes.
that's actually
Yes. Carry on, carry on.
two counters to that, my lords.
Yes.
One, that in a fight between right to shelter and right to conservation of a natural resource, would it necessarily follow that the
Mr.
natural
Counsel,
resource?
does the right to life only fall or is only the right of human beings, not of the animals
My lords, I
and other
understand.
living beings?
My lords, I understand, but in a constitutional state or especially a welfare state,
Yes.
isn't it a responsibility of the government to ensure that at least three things are done? One, when you're taking away that right to life, you serve notice.
Yes.
Two, in the larger constitution, and this follows from S.L. Kapoor and Olga Tellis and etc.
Yes.
So that's one. Two, that even if that argument of utilitarianism is taken in or is accepted, would it not follow that in a welfare state, you do have to balance the right of those who are at the lower strata of the pyramid? So therefore, that's important to understand, especially when there is a parallel or an alternative land policy where rehabilitation or resettlement of the appellant and other affected people is supposed to happen or can happen. So let's, the first issue that I'm trying to point out is also equally important. Can the court allow a retrospective application of a prospective legislation?
Which legislation?
My lords, the Water Bodies
What
Act of
bodies?
2008.
Read para 39, please.
Yes, my lords. A submission was made on the prospective applicability of the Water Bodies Act 2008. The aforesaid submission may be a substantial one from the legal angle. However, the basic burden upon the petitioners is to establish that they have been residing in the aforesaid lands from a period prior to the coming of the said act. Admittedly, the same would require a factual determination which would involve adducing of evidence which is not within the ambit of this court under 226. My lords, my contest against that is that when there is a documentary evidence on record to suggest of the state itself that these petitioners have been residing on the said land before the enactment of the act, then the court cannot wash it away by saying that it is not acceptable or it would require a fact.
What is the evidence you are referring to, please?
May I bring your lordship's attention to page 55 of the appeal?
Yes. What is the electricity bill?
Yes, my lords.
Electricity bill doesn't give any indication.
But my lords,
Yes.
this is a recognition of long physical existence. It specifically states on the last three lines, so and so have been permanently residing for the last 12 years. Their neighbors, namely so and so, are enjoying.
You are reading at page 55.
Yes,
Who has written this letter?
Lords, this letter is by the office of the circle officer, Dispur Revenue Circle.
Yes.
So and so.
And what is the land which is referred to in the area which is referred to in this letter?
DAG number
Is it
Yes, my
same
lords.
DAG number?
Yes, my lords. This
Yes.
is the appellant Sri Khireshwari Saikia
Yes.
on line number 3, my lords. So therefore, the state itself recognizes that.
Just hold on.
My lords.
Yes. As a letter written by a circle officer, can it be attributed to the state?
My lords,
These letters, we have seen instances how these letters are managed.
my lords, it
What is the
not,
dispatch number of this letter?
my lords,
What is the dispatch number of this letter?
Dispur 114 by 2017 by
Yes.
1597.
Yes.
My lord, my argument is this, that if you have recognized someone's long physical existence,
Simply a
not
circle
through-
officer saying, is that a recognition of right by the state, sir?
that's not the only recognition, my lords, I'm
Yes.
referring to. I'm also referring to voter ID cards, Aadhaar card, address recognized. You're building roads on that same land. You're also building government offices on that same land. Now, this is also a conceding of the fact that there are people who are living on that. And that's a human aspect to this entire angle that I'm trying to present.
We can't be swayed in this manner when the human beings, for their greed of land, just eat into the lakes, rivers, water bodies,
My lords, I
right,
understand.
left and center, and officers who connive with them, rather they should be taken up halt for disciplinary proceedings.
I
We are
understand.
not going to come to the aid of these people. That is for sure.
My lords, I understand.
With
what's falling-
technical arguments, we'll deal, don't worry.
My lords, I understand what's falling from this court. I'll
Yes.
just point out this one thing,
Yes.
that in a dispute between conservating,
There is no dispute at all.
in
There
conservation.
is no
of natural-
dispute. You have rampantly finished off the lake that is apparent from the evidence which is available on record. What was the original area and what now we are left with?
I understand that.
Yes,
So isn't a service of notice mandatory under the constitution? Yeah.
rank encroacher, what kind of notice is required?
My lords, in
You
encroacher,
see, service of notice in a situation where there may be a possibility that you can claim settlement, right? By a long position. Can you claim settlement on a water body?
my lords,
Just let us know that.
my lords, this land was supposedly brought into the Water Bodies Act in 2008, and it's a prospective legislation.
What is the category of the land in the revenue records? Let us see that. Where is the original revenue record
That is not.
of the agreement? That is what is required, sir.
My lords, what I'm trying to point out is that the state has recognized long physical existence. It is
What
much
is the
before.
category of land? Can there be a physical possession on a land which is prohibited to be settled and possessed? Now come out with the argument on that aspect. It's a prohibited category of land.
But my lords, that prohibited category of land,
Yes.
my lords, I'm referring to the regulation of 1886, the settlement rules, which the learned single judge has referred to and said that therefore, because it is under the caste land and so and so therefore notice is not required.
Other than CAS, we are going a step further. What is the category? Till reserve forest, water body,
My lords, it's a government land. I
government
concede
land.
that.
There's a further subclassification.
I concede that, my lords. I concede that. I'm saying that isn't it mandatory based on Olga Tellis and the nature of the petitioner or the appellant? Is
We
it
are
not
asking you,
mandatory?
we are asking you, can there be any claim of right of encroaching on a water body, and can the encroacher ask that, no, please give me a notice first?
My lords, the categorization as an encroacher may not be supposedly true, my lords, because
What
my
else?
my
What
argument
else?
to that is
Yes.
that what was the
So
state
we'll not
doing?
term them as settlers, sorry.
My lords, what was the state doing for the last 15, 20
Yes,
years?
that's all right. That's a different aspect of the matter, that the officials who had turned a blind eye,
My
they
lords,
should also be proceeded.
my lords, but
that
that's
is
a
for
human-
sure.
That's a human aspect that I'm talking about. There's legitimate
There
expectation
is
that at
no
least,
human aspect in encroaching upon a water body, sir.
I
We are
concede,
telling
my
you.
lords.
Plain
I'm
and
sa-
simple.
I'm saying that if there is a long physical existence,
Mr. Council, do we have, what is the category of the land in the revenue record?
It is.
Do we have the record?
No,
Khas land is one thing. Is it recognized as a water body?
Yes, it falls within the category of the water bodies. Act.
Let's see the record, please.
Yeah, my lord.
the Water Bodies Act is in 2008, my lords.
Not the act, sir, even in revenue records.
That's not on record, my lords. That was not even before the learned single judge.
We can see it in appeal, no issue.
I'll have to produce it because my lord, in that Water Bodies Act of 2008, my lord, the schedules have been called out,
Hmm.
and in the schedule, bug number 602 specifically finds a mention. So may kindly peruse if it is the Water Bodies Act.
Even apart from that, even in the revenue, wherever there is an entry, the category of land is mentioned, where it is a talab, nadi, nala.
It is my lord, government wasteland. Government wasteland, meaning thereby, my lord, it is government land. And the settlement rules, my lord, define government land as wasteland.
Wasteland or wetland?
Wasteland.
Wasteland.
Wasteland. Because it is government land, my lord, the government has the prerogative, my lord, to use it.
Very state of affairs.
There in the
That
water bodies,
subdivision has to be there.
in the Water Bodies Act, my lord will find it at Schedule 3.
Schedule 3.
Schedule 3, my
Page
lord.
3, my lords.
Schedule
Yes.
3. Schedule 3, my lord, row number 2. The second row, revenue village, all land of Doug numbers. In bold letters, lordship will find, my lord.
Dog numbers, yes.
Yes, 602.
Hmm.
Second line.
Hmm.
So this is the area, my lord, where they are residing. And it has been admitted by them, my lord, in the writ petition, at paragraph number 2. They say, my lord, it has been specifically averred. Petitioner number 1 occupied small portion of government land measuring 1 kotha 9 lesser covered by dung number so and so 602.
602 is in schedule of land A, B, C. Which one? You are talking of the schedule.
Yes, my lord.
Their dark numbers are in. There are subcategories A, B, C.
Yes.
Which revenue village?
My lord, schedule of land, my lord, at category A.
A.
Category A, my lord.
Dark number is 602.
602, lordship will find it at the second line.
Yes.
602. So therefore, my lord, the appellant herein is admittedly in occupation, my lord.
Declaration of water bodies, subclause section 3 of this act.
My lord.
It has been declared to be a water body. There is no challenge to that provision.
Milords, I'm not challenging the provision, Milords.
So once it is a water body, you have to move out, sir. There is no way out.
Milords,
Either challenge that declaration.
Milords, I'm just submitting that can a prospective application.
It is not a prospective. It declares the category of land, which should have been there long back. The declaration should be in the revenue record itself.
Milords, but
We
there
don't
is-
know. I am at a loss, really, because in any other state, you pick up the revenue entries, the category of the land will be mentioned. There is no need even to enact this act. The category should be there in the revenue record. Government land, what is the category? Catchment area. A pond, a river, a nala, grazing land, VGR. Is VGR entered in the revenue record or not? Mr. Chaudhary, I don't know where, I am at a loss.
The land would be described definitely.
The description is
Yes.
bound to be there.
Description-
Where is the revenue entry? The original,
You.
that will be right from the time of settlement, original settlement, the description will come in. If it is a water body, it will be mentioned talab or
I
Pond.
think in vernacular they call it jala, jala hut.
वो जो भी वो revenue के अंदर होना ही होना है. So if that is there is no need of this water bodies act at all. Because it is already declared, its category cannot be changed.
That's why, my lord, this operation is being taken because the original map shows this
That
land
it
is
is
meant
allowed.
for this particular.
Yes, precisely, precisely.
Stream. That's why.
Anything catchment area,
So why I have made that submission? Because it is incorporated in the rules,
in the
in the settlement rules. Now the settlement rules, my lord, say wasteland means land at the disposal of the government.
oh, gentlemen, at the disposal of the government, you may settle people on that. That can be allotted. But a water body's land can never be allotted.
No, yes, therefore now by dint of this, my lord, act coming into.
That is what his argument is.
My lord.
That you declared it later, they were settling on that earlier. What you were doing then? That is why we are asking you, come out with the original revenue record tomorrow, day after tomorrow,
Yeah, after
Milords, day after tomorrow would be a little difficult.
Monday.
Monday.
Land Council, Mr. Your good name, please.
Anurag Tiwari. Milords.
My lord, Arbor Pujari.
R. Pujari appearing for the respondents shall keep the original revenue record pertaining to the dark numbers in question available for the court's perusal.
My lord.
List on
Milords,
13th.
can it be after the 17th, Milords?
Very well. 19th June.
Much obliged. Milords.
I'm so obliged.
Item number 11.
May it please your lordship. My lord, before my learned senior start, my lord. Lordship may kindly have a look the order dated 17/5/2022 for a moment, my lord.
17/5.
My lord.
22.
My lord.
Yes.
For the last paragraph, my lord, may I read, my lord?
Mhm.
Under the circumstances in the interim, we are of the view that till such process for promotion is completed as directed by this court, the petitioner will be allowed to remain in the present post, junior assistant district level, which he was holding at the time of the passing of the impugned order. Necessary alteration, modification of this order will be considered after the promotion process has been completed. And Lordship, we have filed an affidavit, my lord. At the DPC meeting was already held, and we have selected the person for promotion. The petitioner is the writ petition, my lord. And because of the pendency of this writ appeal, we did not pass the official order, my lord. This is the case. In fact, this Lorne Singular has rightly passed the order, Lordship. The Lordship may dismiss it.
For that, he has to argue.
My lord.
Huh?
My lord, she has pronounced the judgment, lordship has to sign only.
That's her skill, sir. You have to appreciate her lawyering skills.
Yes, yes.
Yes.
I obliged, I bow down, my lord.
Yes.
I bow down, my lord.
Okay, now carry on.
My lord, what were my learned friends submitted? The initial part is all right, my lord. The second part that she prayed for a dismissal of the writ petition.
Writ appeal.
Oh, sorry, writ appeal.
Yes.
She is arguing against her affidavit.
Okay.
There is no pleading as such that the promotion to me was illegal. But what happened in 2005?
You appear for the government.
My
Yes,
lord.
department.
I paid for the Inland Water
Department.
Transport Department.
Yes,
my lord.
department, not for the
Yes.
government. my lord.
All right.
So my respectful submission, my lord, in the year 2005, a large number of master roll and workers employees were regularized by a common order by the government.
Mm.
And that, in that order, my lord, it was, if I can read, my lord, in the, my synopsis itself, it is there, my lord. The posts which are created herein in different categories for regularization will be personnel to the incumbent and created by name, which will be automatically abolished as soon as the said incumbent retires, is promoted, dies, or resigns.
Mm.
Now, my lord, the whether after reading this, there is no restraint from anywhere that the person who were regular, whose services were
He will not
regularized
be promoted any further.
any further. There is no restraint from anywhere. In my department, there are 100 persons who were promoted, similarly situated persons were promoted to
Either there has to be a promotion or otherwise there has to be benefit of MSCP. Either ways.
That is the
Because it's a
difference.
stagnated post, then there will be MSCP.
Yes, MSP. Now
Yes.
the question is, almost, I have given the details who were promoted in the similarly situated persons.
Your promotion was questioned on what ground?
Yes, my promotion was questioned by the writ petitioner saying that he is senior to me and he should get the promotion before me.
Yes.
But the latest affidavit filed by my friend saying that his promotion, the writ petitioner's promotion is already ready and his promotion is not, he has not proposed to be promoted against my post. He is the Arakati. There are the two different posts, my lord. One is, I was Khalasi and he is Arakati. Arakati is a technical post who helps the sailor in.
So what is the next post for promotion?
Assistant.
What is the next
assistant,
promotional
office
post?
Assistant, my lord.
Office. So both
Junior
of you,
assistant, junior.
both of you will get promoted to the office assistant.
Yes, yes.
So how many posts are there?
My lord, there were many posts. I was given promotion in 2018.
18.
And he has been given promotion now in 2023
Okay.
in a different post, not against my post.
It's a different post.
Yes, yes.
How do you say so?
Kindly read, my lord, annexer 1 given by my friend. Minutes of this additional affidavit they have filed.
Just let's see. Yes. DPC dated
Yes,
31st
DPC
March.
dated 31st March 2023. The meeting was chaired by Sri so-and-so, director so-and-so, this is the name. There is one number of vacancy in the post of junior assistant district level by promotion from the cadre of grade 4 employees who have passed degree examination in a discipline from recognized university or any examination declared equivalent therewith 7 years continuous service as per the Assam Ministerial Establishment Service Rule so-and-so, dated so-and-so. On careful examination of the gradation list, roster point of the incumbents, ACRs and zone of consideration, the committee recommended Shri Sarat Chandra Hazarika, Arikati, to the post of junior assistant district level. There is no departmental proceeding against the recommended incumbent.
So there is one post and against that he has been promoted.
Promoted.
Then
No. This is not my post. I am holding my post. This is another post which was vacant.
so this is after accounting for your post that one more.
Yes, of course. Mila.
Lordship, may
Let's
kindly-
see why your promotion has been interfered with.
My lord may kindly have. the
Just hold on. Why
My
your promotion was interfered?
interfered with only because that I cannot, my lord, there is a judgment, my lord. I will take your lordship to that judgment. I have annexed the judgment.
The person who have been regularized against personal posts cannot be promoted to, that is an ex-cadre post.
Yes.
So person who is confirmed against an ex-cadre post, the single judge holds, and rightly so. That is the law. That
No,
ex-cadre
my lord,
post,
the,
no promotions.
no, but the similarly situated, all of the persons are getting. It's
There is
not-
that pleading, that
Yes.
similar situated persons have been given promotion.
My lord, we come to page 13, my lord.
1-3
1-3, yes, my lord.
of the writ
Of my
appeal.
appeal memo, my lord.
Page 1-3. Was there any such pleading in the writ court?
My lord, writ petitions, my lord, we have submitted, we have filed our written statement.
Let read.
Sorry.
38 persons has been.
Yes, no, it's more than 38. At that time, I was informed that 38. Now it is more than 150, my lord.
Hmm.
So, my lord,
What do
only
you say to
because,
this? The promotion of the writ appellant has been interfered only on the ground that it was an ex-cadre post.
My lord.
And there is a pertinent statement
My lord.
that you have promoted 150 such people.
Lordship, that instruction I will get, but Lordship may kindly have a look page 165 for a moment, my lord. The law is settled by this honorable division bench of this honorable court.
165,
My lord,
that no promotion on ex-cadre post.
my lord.
yes, yes.
So
The
then why you have promoted 150 people?
that instruction I don't have right now, my lord, but they cannot take the benefit of illegality of the department. But this.
Oh, you are continuing that illegality to
No,
150
Lordship,
people.
that's why-
Then all right, revert them immediately. File an
Yes.
affidavit. What is your answer to this?
Lordship, regarding that, I will file affidavit, my lord.
Para F, where is your, where is the pleading in writ court with this government? Read please.
My lord, I'm coming to this.
Hmm.
My lord, I have annexed document as page 94, my lord.
94,
Yes,
document to the effect. These are persons who are all confirmed
yes.
from
my lord,
Kalasis.
my name is at second, serial number 2, Sanjeev Kumar Das.
Yes.
Above me, serial number 1, was given promotion, then she retired. Then below me, Abhijit Bhattakur, he got promotion, is still working. And there are many, my lord, I will give a list. I have annexed the list who is getting the promotion, my lord. That your lordship can see at page
But these are great force. Where is the promotion?
yes, page 146, my lord.
146.
Page 146 onwards, these are all the promotion orders who got the promotion from grade 4. And they were confirmed,
All confirmed on
yes, by the common order, my lord,
common order.
2005.
All right. The land council representing the appellant is urged that as many as 100, almost 150 employees at par with the appellant who were confirmed from muster roll and other such temporary services in the year 2005,
Yes, my lord.
comma, have been afforded promotion. Whereas, comma, the promotion of the appellant and are working in their post, whereas, comma, the promotion of the appellant herein has been interfered solely on the ground that an employee confirmed against an ex-cadre post cannot be considered for promotion. The logic is right. Temporary creation of post cannot automatically add to the cadre strength. That is the concept, basically. But well, let her come out with the affidavit.
My
My
lord.
lord.
The counsel for the respondent department file an affidavit. Promotion? No, confirmation. That's not. What is the order of confirmation? It's regularization, please.
It's a personal post, my 117, my lord. Page 117, Lordship may kindly have a look.
That is ex-carter post, we
My
understand.
lord, my lord.
But how many people were confirmed that way?
Lordship, that
1055.
1,000.
All persons will be unsettled if this is to be allowed.
lordship, I will get that
So
instruction.
then you already revert all others.
The difficulty is my
So that the
friend is
post will become
arguing
bigger.
beyond pleadings, my lord. My friend is arguing beyond pleadings. That is the difficulty. She doesn't have that
He's
instruction.
arguing on a sound principle that an ex-carter post employee
No.
cannot be offered promotion
My lord,
because that it results into adding to the cadre strength.
but the hands are tied her because her clients.
All right, let us,
No, lordship,
let us
because
have
we
the
are not
affidavit.
filing the writ appeal. We are not agreed by the honorable single judge order. My lord, that's why we are not filing the appeal.
Yes,
My lord.
this pleading was there even in the single court, single bench petition.
Lordship, I will file the affidavit.
You did not set aside his promotion. It was under the direction of the court. You still support his case. Is it right?
Lordship, I will get the instruction. and
Okay.
affidavit.
Did you oppose the promotion, the prayer in the writ petition or not?
No, they did not.
In the writ petition,
They did not oppose my promotion.
the prayer of the petitioner, did they oppose it or not?
They neither oppose their promotion. They in their manner. I'll page 63 once.
I'll
For a while.
read out.
Page 68 is the affidavit filed by them, my lord.
Yes. What do they say?
Plain and simple affidavit, last paragraph from 68 onward, that with regard to the statement made in paragraph 2 and 3 of the writ petition, the deponent states that it is a matter of record and hence no comments to offer. That with regard to the statement made in para number 4.
All right, Mr. Chamo, your client continues to hold the promotional post.
Yes, yes.
All right then.
Well, matters can come to a conclusion, my lord, because the writ petitioner's promotion has been effected, just waiting for a green signal from this honorable court.
So can we
If
record
that
your
is
statement?
allowed,
Can we record your statement that his promotion can be given effect to?
But this will not interfere in my promotion. my
Learned
lord.
Counsel, Mr. Chamo further submits that as the DPC has recommended promotion of the writ petitioner respondent number so and so, comma, the said decision, if given effect to, comma, would not act as a detriment to the detriment of the appellant because the post on which the respondent has been promoted is different from the post which the petitioner appellant is holding.
Yes, my lord.
In this view of the matter, comma, the respondents are free to proceed with taking the consequential steps in terms of the recommendation of DPC. Dated so and so.
Obliged.
List of 4 weeks.
My lord. I'm deeply obliged. my lord.
Item number 12.
No, the matter relates to entitlement of the appellant, my lord, for grant of parole.
Parole
Yes.
is been
Convicted under, my
convicted
lord,
for,
convicted under NDPS Act.
okay, very well.
Now, my lord.
Read a judgment of Rajasthan High Court
Yes,
Division
my
Bench,
lord, we have got
Shambhu
the
Ram.
full bench judgment
Yes,
as well as, my lord, another
So
judgment,
the
Shambhu
state-
Dayal.
Shambhu Dayal. So
No,
the
I'll
state,
rely on Shambhu Dayal, my lord.
state authorities can't do it. It has to be, the application has to be filed to the Union of India. State laws, parole can't be granted.
No,
That is what Shambhu Dayal says.
yes, yes. So,
So,
my lord, my only submission was.
yes,
Here in the present case, we are challenging the virus of the rule 4(8), whereby, my lord, this ban has been brought in. That's the
That is
challenge in the,
not from the rule, that is from the act. 32A
no.
is the parent provision.
My lord, in Dadu's case, my lord, it has been said, my lord, that despite section 32.
That is for bail, not for parole.
No, parole also, my lord. There is an observation, my lord.
Yes, but who
if
is
a
the
law-
authority
para-
who can, Mr. Chaudhary,
My lord.
who is the authority who can consider? State has no
that is-
business at all.
Yes, that is the case.
Let's see
My
Shambhu
lord,
Dayal.
the full bench judgment of the Rajasthan High Court said, my lord, that under 1958 of the Rajasthan rule, he cannot be released. We are also saying, my lord, it has to
Yes.
be released under 1911-55 notification of the Government of India, issued under subsection 6.
But then the prayer has to be made to the government of India, sir. There is,
No,
that
my
is
lord.
what Shambhu Dayal says.
Yes.
There is a competent authority formed by the government of India
Yes,
for
yes.
dealing with parole cases of NDPS convicts.
No, my lord, only thing is here in this case, relying upon the Assam rule, which was amended in 2014, my application was rejected. My case is, my lord, my case should be considered under the 1955.
Who is to consider? Where will you file the application?
My lord, that's not very clear, my lord.
No, that is very clear. Read Shambhu Dayal.
My lord,
Read Shambhu
Sambudayal, my lord, para 20, the operative portion of the
Do
last.
we have Shambhu Dayal's
Uh,
copy?
Sambudayal,
please?
yes. I've got it. I've got
Yes.
it. Already given on the last occasion.
We had taken out that judgment and shared it with the council, was previously appearing.
I'm told, my lord, in that blue color file, the judgment is there. My learned friend says.
This-
My
Copies, yes. Read, please.
lord, page 19 of Sambudayal, my lord.
Yes.
In view of the discussion made above, the two questions framed by this court are answered in the following manner. Whether the Rajasthan prisoners released on parole rule 58 are applicable in the cases where sentence of imprisonment is for an offense relating to matter to which executive power of the union extends, such as under NDPS Act. Answer. Rajasthan prisoners released on parole rule 1958 are not applicable in cases where conviction is under NDPS Act and also where convict is sentenced to imprisonment for an offense against any law relating to a matter to which executive power of the union extends. And such cases have to be dealt with in accordance with rules of
Yes.
55 framed by the central government.
Yes,
It doesn't say that by the central government. My humble submission is perhaps, my lord,
yes.
subject to.
The authority has to be nominated.
Yes.
For that purpose, you will have to implement the Union of India. To find out who the authority is under competent authority,
Or
under the
lordship-
rules.
Lordship will direct the competent authority to consider my case, my lord.
So you make that prayer, we'll permit you to file your application to the competent authority under so and so.
No, the competent authority.
That was the
has to
standard order in Rajasthan,
Yes.
that you approach the
I
competent
was
authority.
also thinking of that, my lord.
That
But
is
in
what-
Sambudayal's case, my lord, we couldn't find across a straight cut answer that the application has to be filed before. That is why.
Where
my
are
lord,
the rules of 55? Let's have the rules.
58 rules, my lord.
58 rules.
No, that is, I think, rule 1C of the Rajasthan.
Framed by the central government.
Yes, that is there, my lord.
Where
In
is
our
that?
application. Page 119, my lord.
Mm.
120. Operative portion. In exercise of the power conferred by subsection 6 of section 401 of the Code of Criminal Procedure, central government hereby makes the following rule. Where a petition for suspension of execution of a sentence of imprisonment or for remission of the whole or part of the sentence of imprisonment is made by or on behalf of the person sentenced to imprisonment for an offense and against any law relating to matter to which executive power of the union extends, and the person sentenced to such sentence or imprisonment is in jail, the execution of the sentence shall be suspended and such person shall be released on parole, subject to conditions specified in Rule 3 for such period, not exceeding 50 days as may be necessary for obtaining orders of the central government on a petition if state government of the state is in which such person is detained in jail is satisfied, that immediate release of such a person on parole is rendered
So
necessary by.
what you will be required to do is, you will have to implement the Union of India.
We got
Implement
it.
them and then we'll ask them, who is the competent authority under
my-
this
My lord, can I have it on Monday next?
council? For the
Monday next.
petitioner
my lord.
seeks
Monday.
permission to implement the Union of India as a party respondent in this writ petition. The prayer so made is accepted. Amended cost shall be filed within 2 days. After supplying advance copy of the writ petition, we provided to learned Deputy SGI list on Monday.
Monday, Tuesday, my lord. Monday I'll be. not there.
Tuesday.
Tuesday.
Okay.
Deep level. Yes.
Yes. You are making some mention, Mr. Saikia? AG sir? No. Right, you appeared at 1 o'clock, so we thought you want to make some mention. You have some matter left over. You unmute yourself. Unmute your device. You need to unmute yourself, Mr. Saikia. All right, come back at 2 then.
Yes, yes. No, I have nothing to mention.
Okay, okay. We thought you
And-
just
no.
opened the window. We thought you
Yes,
had
window.
mentioned.
uh,
Okay.
May I please, Lordship?
Yes, please.
My lord, only yesterday the papers were handed over to me.
Okay.
I need 1 week time to.
1 week's time.
Yes.
You are appearing for
1, 2, and 3.
land council. Your good name, sir?
AC, sir.
AC Sharma appears for the response numbers 1, 2, and 3. For the comment, 4 and 5,
4 and 5, I am appearing, Lordship. I have received the
MS
instructions, Lordship.
D. Bora puts in a standing counsel health appears for the response number 4 and 5. The service is complete. Mr. Sharma prays for and is granted 2 weeks time to complete his instructions. The interim order dated 18/5/2020, 6 and 7 you are appealing. 6 and 7 in Kazi laga dijiye. Interim order dated 18/5/2023 shall remain in currency till next date.
I will file it.
But the matter is to be remanded otherwise. If you agree, we can do it today. The order was passed without hearing the appellant. If you feel like it, the result will be the same, even on the next date.
Maybe fix on Friday.
Very well, Friday, because it has to be remanded.
Yes.
If you are agreeable, we can do it right now. What is the problem? That is a matter of record, that he was impleaded, not heard.
He got the paper yesterday, only paper.
Doesn't make a difference. He knows the judge, what the judgment is and what the flaw is. The counsel knows it very well. So if you say we are just deferring the inevitable,
Day after tomorrow.
day after tomorrow, list on so and so. Okay. ये उसमें डाल देना. Saurabh Khan. Yes.
Supplementary list, item 29.
May I please, Lordship?
Yes, please.
In this case, yes, Lordship, on the last occasion, that was last week, Lordship, the writ petitioner prayed for some time to file a reply.
Rejoinder,
They filed a reply at the last hour yesterday,
Okay.
raising certain factual spec, and yesterday was a state government holiday. So we need to counter these facts which they have alleged in our a reply. So I'm praying for 10 days time to give a counter reply to this.
So far, even if I don't press into that affidavit, I have not
Yes.
stated anything new. What I have brought on additional affidavit is just the mention there, because you also recall, this is that matter relating to the appointment of the professor.
Mr. Kumar, whatever, you have filed something at the last hour yesterday. They say that there are some facts which need to be controverted, and that opportunity has to be given.
I have just complied, but.
All right, Mr. An affidavit, rejoined affidavit has been filed on behalf of the petitioner yesterday.
No, we had filed it on Friday last, sir.
On 5th June, it says. In our file, it has been received on 5th June.
Okay.
Then Advocate General Mr. Saikia, appearing through VC, submits that as some factual assertions have been made in this affidavit, it is essential to file an affidavit on behalf of the state government in reference to this rejoinder. A sur-rejoinder affidavit on behalf of the state government. List on, when do you want, Mr. Saikia?
Lordship, let it be on 22nd.
22nd, ad interim order date so and so shall continue till then.
Deeply obliged.
Daily list, item 14.
Lordship, in this case, the required affidavit has been filed today only. Lordship may fix any date next week, Lordship.
Affidavit on behalf of?
Writ petitioner. We have to file, Lordship.
You have filed it.
Lordship, today.
Today.
Affidavit on behalf of the petitioner has been filed today. And counsel presenting the parties pray for time to argue the matter. List, then it goes after some direction.
After 2 weeks, my lord, date maybe.
Now it will not be possible, sir. List on 25th July.
Item number 16 and 17.
अच्छा interpretation.
May I please, your lordship?
Yes.
This is near 2 of 09, lordship. First, your lordship, I'll take up the FI, your lordship, kindly go through volume 1, page 4, your lordship, kindly.
What do you want us to look at?
FIR.
FIR.
FIR, lordship. Page 4,
Just page 4 of what, sir?
volume 1.
Volume 1. Can you give us a brief outline, please?
Brief is that this Jivanshu Pal and Golon Dolagap, the other accused appellant, they were traveling in a Scorpio. So
Okay.
they were intercepted, and from Jivanshu Pal, an amount of 32 lakhs 11,000 were recovered. And thereafter, they filed an FIR stating that that amount of money was meant to give to the DSP.
Same old story.
Same old story,
Okay.
lordship.
Let's-
That your lordship
let's-
kindly say, in
yes.
page 4,
Heflong to Dingmuk.
lordship, Dyongmuk PS.
Dyongmuk.
Dyongmuk PS 3 of 09. Last para, lordship. I beg to report that on information received from high-level source, that some person workers of NC Hills Autonomous Council are going to deliver huge amount of money to DHDJ extremists somewhere in between Haflong to Dyongmuk for the purpose of procuring arms and ammunition and for promoting organizational activities with a view to wage war against the state. Accordingly, I, along with available force under the guidance of Deputy SP, headquarter Haflong, checked vehicles coming from Haflong to Dyongmuk and vice versa. That's around 11/2/09 at 3:30 PM. During checking of the vehicle number so-and-so Scorpio, boarded by Golon Dolagapu, MSC NC Hills Autonomous Council, and Sri Jivanshu Pal, recovered cash rupees 32 lakhs 11,000 from the possession of Jivanshu Pal, son of so-and-so. Both the above persons could not give any satisfactory reply on account of carrying such a huge amount with them. Hence, it is proved. So as because they could not satisfy properly.
So it's proved.
It's proved that this money is meant for DHDJ. Now, our lordship will take, I would like to take your lordship to page 8, the charge.
8.
8. Initially, there are 3 charges under under section 120.
So what about the charge at page 7?
7, 8, lordship.
What about 7? Oh, that was
7 is
Samir Ahmed.
That is Samira. Wrongly, it has been.
Wrongly.
Wrongly, it has come here.
Okay. That is the Nia 1.
Nia 1, lordship. Page 8, your lordship will kindly see. 3 charges are there basically under section 120B, 17 and 18. 18, he has been acquitted. He has been convicted under section 120B and 17 of the UAP Act for 10 years. First charge, lordship will kindly say that you entered into an agreement with the members of terrorist gang, that is Dima Halim Dauga in short, DSDJ, to do illegal act or an act which is not illegal, but by illegal means, that is to raise fund for the terrorist gang by siphoning government fund allotted for development of NC Hills District Autonomous Council and handed over the money to the terrorist gang DSDJ through Mohit Hojai to procure arms and ammunition by converting the money to US dollar in order to wage war and to assist in continuing terrorist acts and thereby committed an offense under section 120 IPC. Then the second one, that you during the period from 2004 to 2009 were directly involved in raising and collecting funds or attempted to collect funds for DSDJ by siphoning off and by defalcation of government fund allocated for development NC Hills Autonomous Council. And in doing so, payments were made without supply or short supply of articles, making the rate of the supply articles more than the double of market rate by preparing false bills, vouchers, delivery salons, money receipts, etc. And thereby committed an offense punishable under section 17 of the UAP Act. So that third charge he has been acquitted, lordship, 18.
Conspiracies with Mohit Hojai. Yes.
Now we'll also kindly go through the judgment, the circumstances that I want to point out.
There are only 2 accused in this case.
2 accused in this case.
Mohit Hojai is not charge sheeted. Mohit Hojai was not charge sheeted.
The earlier one is Sasi. Actually, Sasi, Mohit Hojai was there as because he was tried in the earlier case 1. So he has been discharged.
The
here.
conspiracies
That
with
particular
these 2 people.
That particular lordship will kindly see the judgment, volume lordship 6, page.
You just refer to the para.
1183, para 4. There
Yes.
the learned trial court has stated.
Sort of shabby.
Para 4, 1183, lordship, volume 6.
If it was a joint trial, then the judgment had to be common. Separate judgment. Yes.
Para 4 your lordship got it.
Hmm.
Then complying the provision 207, my learned prisoner, learned advocates of both sides on the point of charge, and having considered all the materials on record and case therein, having found strong primacy against the both the accused, frame charge under section so and so, so and so. My learned predecessor also discharged the remaining accused from this case as upon the same facts and
Do
circumstances.
we have
on the
that
record.
reasoned order of discharge?
No.
Where is the order of discharge? Is it available?
That will be in the record. I don't have the order.
That will have a very material bearing on this case.
That's it.
Definitely, then where is the order with you?
Because lordship will kindly see the search sheet. Search sheet, your lordship will kindly see. All of them have been searched, except Babul Camprai, always searched in this case. But
Okay,
as because they have been tried in one, the learned trial court has discharged. Only these two accused appellant they have faced the trial lordship.
Mr. Prosecutor. Mr. Prosecutor. Do we need to hear anything more in this case? You are charging these two people for having conspired with Mohit Ojai to provide funds to the DSDJ. And Mohit Ojai is not an accused in this case. You say that similar allegations is being tried there, but there, these people are not conspirators. So how, without charging Mohit Ojai in this case, you can hold them guilty of conspiracy?
That is one part, because originally all these accused persons were charged together.
Maybe,
Yeah.
but the trial court discharged them.
Discharged.
You should have filed a revision for questioning that order. That discharge order has become final. So that finding that they have been prosecuted on the same facts is incorrect on the face of it. That finding is absolutely incorrect. Do you agree or not? These are not same facts because these two persons are not conspirators in that
Not
case. So you proceed against these two people on the basis of an isolated incident of recovery. Then you try to link them in through some
No.
payments being made to the contractors that same way. So maybe they are analogous allegations, but they are not the same facts. So if you not question the discharge of Mohit Ojai, with whom these people conspired ultimately, we'll see that finding also.
Finding is there in the judgment, lordship.
Finding that Mohit
Finding is
Ojai,
there,
conspiracy with Mohit Ojai,
lordship,
without charging him.
without charging. Finding is there, that I'll point it out, lordship.
Okay,
Now, lordship will kindly go to the circumstance.
yes.
That is para 248, lordship,
Precisely how many witnesses are concerned with these two people?
128 witnesses.
128 can't be for these two.
No,
We have
no.
read the statements of all 150.
Because here also, all the witnesses were examined in this case also.
That we know.
Relevant about.
How many persons are relevant for this case?
Relevant for, so far my accused is concerned. 1, 2, 3, 4.
Might not be
6,
more than
7, 8,
5.
9
9.
witnesses.
Okay, very well. You read on the findings.
First, lordship is a circumstance.
Points for determination.
No, lordship, 248 para, that is circumstance, lordship,
248.
1317
Yes.
page. On the dispersion analysis of the evidence discussed above, the circumstances appearing against the accused Jivangshu Pal can be recapitulated as under.
Hmm.
He was caught red-handed at Tijuari at about 3:30 p.m. along with accused Golon Dolagapu on 11/2/2009 while he was carrying rupees 32,11,000 in Scorpio vehicle. Number 2, though he has stated that the same was taken for processing and supply of pipes, yet the same is found to be not plausible. Then 3, he was found involved with executive engineer PHE, Corona Soika in withdrawing the sum from SBI Haflong branch. Number 4, his specimen signature and handwriting were taken in presence of PW 20 and sent for scientific officer, who on examiner confirmed his signature, PU so and so, so and so. Number 5, Viras Chakraborty, PW 58 has taken a boy to his house for collection of money. And the boy came out of your house carrying a polythene bag containing something that was the evidence. Now you'll also come to the finding.
Hmm.
Para 275, page 1136.
Hmm.
These facts and circumstances, if arranged in seriatim, the same form as same so complete to so complicity of all the above accused person with the charge of conspiracy. To illustrate, accused Golon Dolakapu and Jivangshu Pal were caught red-handed at Tijuari on 11/2/2009 while they were carrying a sum of rupees 32,11,000 from Haflong in the official vehicle of Golon Dolakapu.
What he was, he was working as a member of the,
Who?
he was a member of the executive
Jivangshu, no,
council.
he was
Then
not a member. He was a
Then-
contractor.
So
was a
official, what is an official vehicle?
No, he was a member of the
Council.
Autonomous Council.
So that's what we are asking you.
Dolagapur.
Yes.
Then lordship accused they were carrying a sum of 32 lakhs 11,000 from a flowing official vehicle of Gorong Dolagapur. Accused Mohit Horai and Joyanto Ghosh and Devasis Bhattacharjee remained present at Hotel Pragati Manor in month of 2009 and compelled two executive engineers of the PhD department and CHA to issue checks in favor of March trading a farm registered in the name of Devasis Bhattacharjee, in the name of which accused Joyanto Kumar Ghosh, Devasis Bhattacharjee and Sandeep Ghosh used to do business. The checks issued consequent to the episode Pragati Manor were encased on 29/3/2009 by opening.
Oh,
one
these
account.
are all findings of NIA
Findings of
1.
NIA 1.
So where is the finding of NIA 2?
Then the lawsuit will come, but lawsuit will kindly see after 2, 3, 4 lines. But there is no direct evidence to show that some.
Just hold on.
But from Bhatia lawsuit will find.
But there is.
But there is no direct evidence to show that the sum carried by A1, A2. A1 is Jivangsu Pal,
Hold on. Yes.
where the sum encased by accused Devasis Bhattacharjee in the last part of the month of March 2009. Before his arrest, also accused Prasendra Hoja carried a sum of 1 crore and 2 crore and 1 crore on 3 occasions to Kolkata and handed over to Malsingh Kemi, who converted the same to US dollars with help of George Damthang and handed over to Phallan
Mr.
Sana.
Das, who is Prasendra Hoja in this case?
That's why.
How is he an accused in this case? If it was a joint trial, there had to be a single judgment. And if it is a different trial, separate trial, being done parallelly so as to facilitate the prosecution, that the witnesses may not be required to be examined twice over. That is the only thing which has been done. So it is not a joint trial by any stretch of imagination. So it is not a joint trial, then these persons are not accused in this case. So that is a misdescription. Yes.
At the direction of accused Mohit Hoja, additional chief engineer Sri Karuna Sakya has issued to Dilip Fonglo checks who have handed over the check amount after.
Oh, leave this. They are not, these are.
Again, near one.
Karuna Sakya handed over Dilip Fonglo. And these are not, these two are not accused.
Not accused, no.
Okay, right.
Who have handed over the check amount for after encasing the same to Mohit Hoja, who transmitted the same to Kolkata to be received by accused Joyanto Kumar Ghosh. Accused Arish Khan has awarded contracts to the firms registered in the name of Devasis Bhattacharjee in contravention of all norms and procedures and thereby facilitate siphoning of government fund of social welfare department to DSDJ. Again, official notes in the name of accused Mohit Hoja, addresses to Principal Secretary and Hills, Autonomous Council and bills, challenge in the name of farm of accused Devasis Bhattacharjee.
So these are again NIA 1.
NIA 1 part.
Yeah.
And challenge and bills in the name of some self-help groups whose existence were not found by the staffs of the postal department. Again, NIA 1 lawsuit. Were retrieved from the hard disk of the official computer so RS.
All NIA 1.
All NIA 1 findings.
Where are the findings against these two?
Then again, 279 year lawsuit will kindly come. Again, along with the NIA 1, his finding is the lordship. Para 279 year lawsuit will say. And having considered all the material particulars, we find that the prosecution side has succeeded in bringing home the charge of conspiracy under section 120B against both the accused persons beyond all reasonable doubt. It is to be mentioned here that accused George Damthang has turned approver and granted pardon, and accused Samir Ahmed had pleaded guilty and convicted already. The prosecution side has been able to establish beyond all reasonable doubt that accused persons, namely Golon Dolagapur, Jivangsu Pal, along with Arish Khan, Karuna Sakya, so and so, so and so, so and so, to do an illegal act which is not illegal, but by illegal means to help them in raising.
Forget this language. Now you just tell us who are the witnesses who even provide a remote link between Mohit Hoja and these two accused.
No witness at all. No witness.
The trial court must have relied upon something.
Only one witness is there. PW 58 will also kindly see.
The one who says that bag was taken.
Bag was taken, that part. Biraj Chakraborty. Only that part is there. 57.
Okay, to cut it short, you just let us know. As counsel,
I'll
please,
read out
please,
Biraj Chakraborty.
please, we'll hear you.
Lordship.
You just mention the names of the witnesses who have taken the names of these two accused in their entire evidence.
One is PW 13. He is the one of the investigating authority.
PW 13, IO. Name, what is the name?
Muhammad Khan. His name is
Noor Muhammad
Khan. Then Ratneshwar Das is the informant of this case.
PW
16.
Ratneshwar,
Then PW 20, Navajit Borgohain.
Navajit.
He was the witness to the specimen signature.
Hmm.
Then PW 22, he is the FSL, Tajuddin Ahmed.
What is the name?
Tajuddin Ahmed, Lordship,
Hmm.
PW 22.
Yes,
Then-
his evidence, the FSL report was not relied upon.
It was relied upon, but no independent evidence is there.
No, no, all right.
Only the opinion is there.
Okay.
Then PW 54, Virendra Kumar, who granted the sanction, according to the sanction.
Virendra Kumar.
Virendra Kumar, PW 54. Then PW 57, Viraj Chakraborty. Then
Virat.
Viraj Chakraborty,
Yes.
regarding polythene bag.
Hmm.
PW 68, Ram Prasad Sharma, he is the driver of the vehicle, he was witness. Then PW 72, Srivel Mesa,
PW 68.
68, Ram Prasad Sharma.
PW
72, Srivel Mesa.
Srivel Mesa.
Then the IOPW 128. These are the witnesses, Lordship. So for.
What is the name of 128?
Kharak Singh Thakur.
Khadak Singh.
Kharak Singh Thakur. 57%.
Okay.
Now we'll also will kindly come to volume 2, page 424. The Viraj report is evidence.
Volume 2. Do you have you don't have the summary of the evidence?
Summary, I don't know.
You could have done that, sir. We'll have to pick out all the volumes.
These are small witnesses, Lord.
Okay. PW
57 in Niyaki. Page 424. In the year 1981, I joined as LDA in town committee. Thereafter, in 1995, I was transferred to PHA Haflong Division. In the year 2009, remained as UDA in PHA department. For the release of fund, etc., from government to PHA department, I had to come to Guwahati and get the work done. In the month of January 2009, Mohit Hozai, CEM, called me to his chamber and gave me a piece of paper containing some name and asked me to take it to Karuna Saikya, who was working as in charge additional chief engineer, for placing order in favor of those persons who were in the list. I remember the name of two persons there, Munna Fangloso and Dilip Fangloso.
Who are these two are not charged?
Not an accused. After some days, Mohit Hozai again called me to his chamber and told me that he has some discussion with Karuna Saikya and that Karuna Saikya has handed over checks to Munna Fangloso and Dilip Fangloso. And as directed, I had to take the boy to bank as indicated by CEM. Mohit
Who's the
Hozai.
boy?
One boy, that boy part, the polythene bag, Lordship. Boy was not examined. A boy to the bank as indicated by CM Mohit Hozai. And after encasing the check amount, I handed over the amount to the boy, who was authorized to receive the amount on behalf of Mohit Hozai. Thereafter, again, I was called by Mohit Hozai and directed me to take the same boy who had gone earlier to go to the house of Jivangshu Pal. Here is the evidence, Lordship, for collection of some money. Accordingly, I took the boy to the house of Jivangshu Pal, who I know him. As scheduled, the boy went to the house of Jivangshu Pal and came out carrying a polythene bag containing something. So this is the evidence. And that boy was not also examined during trial.
What is the significant part in the cross-examination?
Cross-examination in last about 5 lines from bottom, Lordship. I do not know what was inside the bag which was given by Munna Fangloso to that boy. Thereafter, I
Who is
cannot.
Munna Fangloso?
He's not an accused in this case. Thereafter, I cannot say where the boy went to the bag. I do not remember the date when Mohit Hozai called me for the second time. The boy came to my office, allowing the said boy. I went to the residence of Jivangshu Pal. I was at the gate, and the boy went inside the house and came back with a polythene bag. Thereafter, I do not know where the boy went. I deny the suggestion that Mohit Hozai never instructed me to take the boy once to the Jivangshu Pal and another occasion to the bank to meet Munna Fangloso. During my employment, the concerned department never gave anything to Mohit Hozai, near requirement sector and social science. So this is the evidence. Daniel also will come from Srivel Mesa.
Srivel
72. PW 72. Lordship. Page 472. He is also employer of PHE. In the year 76, I joined sectional assistant PHC department. During the year 2008-9, Karuna Saikya was the executive engineer PHA Haflong. He was holding the additional charge of additional chief engineer. I know KB Mukherjee, who later joined as executive engineer Haflong. From the year 1995, I was holding the charge of KCI in PHA department in Haflong. Exhibit 315 is a receipt memo and so 5 memo documents were handed over to Nia. 315/1 is my signature. Exhibit 85/5 number of documents handed over to police. 85/3 is my signature. Jim Mother, 92/2 is my signature. 91 is treasury transit register, which is maintained by me under hand. Entry dated 12/6/08 by which 40 lakhs was released by council for maintenance. 91/1 is my said entry. This part we can skip. Then you'll also may come to page 474. The payment of the above funds and persons do not find entry in the cash book. All the checks were signed by Corona Soke as executive engineer. I know one Jivangsu Pal who is a contractor of Haflong. Corona Soke had good relation with Jivangsu Pal while issuing the above checks. Corona Soke sat in the house of Jivangsu Pal and signed the above checks. So he sat in the house of Jivangsu Pal and signed the checks. Corona Soke instructed me to write the checks and told me that the connected bill and paper will place later on. But I did not receive any bills, so I could not make any entry in the cash book. First part. I was also examined as witness in a CBI case with regard to the same subject matter. It is not a fact that I did not state before Nia that Corona Soke had good relations with Jivangsu Pal. The aforesaid 13 number of checks which were exhibited by me today were not in favor of Jivangsu Pal. And I further cannot say who has encased those checks from the bank. It is not a fact that Corona Soke did not sign the aforesaid 13 number of checks exhibited by me today in the house of Jivangsu Pal. So this is evidence. Only part it has come is that he sat in the Corona Soke sat in the house of Jivangsu Pal to prepare the checks. Then Ram Prasad Sharma, he is the Caesar witness of the vehicle lordship. PW 68.
Page.
Page 456. I have been working as driver of NC Hills from the year 1992. On 11/2/2009, I was driving a Scorpio of NC Hills allotted to Golon Dolagapu. On the day I was served, Golon Dolagapu informed me that he was to go to Guwahati for some official work. Accordingly, I got prepared and came to the bungalow of the Golon Dolagapu and reached around 10 a.m. But actually, we started around 1:30 p.m. In the vehicle, I was the driver. There was two PSOs, Deepak Burwa and Mangal Singh took me. We picked up one Jivangsu Pal near railway field who wanted to be dropped at the railway station, but finally decided to go with us to Guwahati since we are also going to Guwahati. Jivangsu Pal had a bag with him, which was red in color airbag. When we reached an area called Dimad around 3 p.m., we found there a police barricade. We were stopped by the police and the bags were carried by Jivangsu and Golong Dolagapu were charged. The bag carried by Jivangsu Pal was found with rupees 32,11,000. Thereafter, we all brought to Tijwari where SPDC and other police officers came. From there, we all were taken to Haflong PS. Jivangsu Pal and Golong were taken to police lockup, but we were released later on. A CIJA memo was prepared whereby Scorpio vehicle bearing register.
Broadly, we did not dispute the fact of seizure.
That part we do not dispute. And now you'll also kindly see the evidence of informant.
Of?
Informant.
Informant. PW?
PW 16 lordship.
Volume 1?
Volume 1 lordship. Page 229.
What he will say.
His name is Ratneshwar Das. 229. In 2000, I have joined Assam Police as Sub-Inspector so-and-so. On 11/2/2009, I received information from source that some member of the Council of NCLs carried huge amount of money to be given to the organization DSD for purchase of arms and ammunition between Haflong and Deungmu. Then I, along with DSP headquarters Jagadish Das and 3 PSOs, we went towards Deungmu for checking. We checked different vehicles in between Haflong and Deungmu. Then we proceeded to Tijwari, where around 3:15 p.m. one Scorpio bearing registration number so-and-so was stopped and was checked. On checking, we found one VIP bag with cash amount of 32,11,000. The occupant of the vehicle was one Golon Dolagapu, MSc, NCHE, Jivangsu Pal and 2 PSO of the MSc. They were interrogated, but as they could not give any satisfactory reply, the cash were counted and were seized. Jivangsu Pal replied that the bag and money belongs to him. Thereafter, for safety, we brought the vehicle along with the cash and Golon Dolagapu MSc and Jivangsu Pal and 2 PSO to the Tijwari BSF camp. They were interrogated. We kept the BSF camp, Tijwari, for safety for the night. Exhibit 101 is a seizure memo by which Indian currency of one transaction denomination of 14 full bundle and one bundle of so-and-so were seized. Material exhibit 71 or these are the seizures, Lordship.
Yes.
On the next day, on 12/2/2009, we took all of them to half-long PS and we informed the OC Dungmuk regarding the incident, filed an FIR. Exhibit 95 is the state FIR. Dungmuk so-and-so, number is 3/09 under section so-and-so, so-and-so.
Okay.
Jiwangsu was also shown as an accused. On the same day, I handed over my MCD.
What is the relevant?
Nothing, Lordship. Cross-party loss will come 231.
Yes.
This is relevant, Lordship. I have lost the SI in the instant case. In the FIR, the accused person would not give satisfactory reply for possession of the amount of money.
You are
So I have
reading-
presumed.
Reading at
Lordship, 231 page.
231. Yes.
Cross part.
Hmm.
I have lost the SI in the instant case. In the FIR, as the accused person could not give satisfactory reply for possession of amount of money seized. So I presume that aforesaid money was meant and carried to hand over to the executor. So on basically on presumption, we have been arrested, Lordship, and FIR was filed. Apart from source information, I do not have any materials to show that the monies which was seized on 11/2/2009 by exhibit 101 was meant for handing it over to the executor. No documents to show. The IO of the case has not made the source as a witness from whom we receive information in the search sheet. Immediately after seizure, I have already started the preliminary investigation of the case by recording the statement of the seizure witness as well as interrogating the accused persons. It is not a fact that exhibit 101, the seizure list, was not prepared as per procedure at the place of occurrence and the signature of the witnesses were later on taken. In the FIR, there is no mention of GD number 283/09 of half-long PS on the basis of which the seizure was made.
Claimed the money. Did anyone lay a claim for the money?
Earlier, he claimed for the money, but that was rejected, Lordship. Jiwangsu he claimed because that was meant for his business purpose, Lordship.
Okay.
I have not informed the Dungmuk case.
The fact regarding recovery is admitted.
Recovery is admitted,
Admits that it is amount.
Lordship. Only fact is whether that was meant for DSD or
That
not.
is right.
That is to be seen, Lordship.
For that purpose, what is the evidence?
No evidence, except that Viras support is evidence that a polythene bag carrying something. Only that part is there. Apart from that, there is no other evidence, Lordship.
Okay.
And moreover, Lordship, this Jiwangsu file, he was tried before a CBI also, along with Mohit and Purna Sarkar.
Okay.
There he have been acquitted, Lordship. That will also kindly go.
You have the judgment? Let's see. This is a new development.
Lordship. That was stated before the trial court also. That part also I will say, Lordship. We have pressed the trial court also regarding this judgment, Lordship. He was given benefit of doubt also. Because that boy was not examined and that same thing, polythene bag.
Who has been convicted?
They
Mohit
are
Ojai and
Purna
Karna Sarkar.
Sarkar and Mohit Ojai.
Right.
They were convicted. And that part I have raised it before a trial court in para 326 also we see in the judgment. But that was rejected.
Okay. Yeah.
Para 326 also we can say.
I'll
Of the judgment. Volume 6. The Dallas Council for accused Jiwangsu Paul has submitted that accused Jiwangsu Paul is acquitted of the CBI in the CBI case number, special case number 12 of 2010 on benefit of doubt. As such, the doctrine issue obstacles were offered CI in this case.
Okay.
That part, so it was thereafter 327 rejected. Having considered the facts of the case, we are of the view that the ratio laid down in the said case law is not applicable in all force to the facts circumstances here in this case. Submission is accordingly stands rejected. So it was pointedly backward.
ये भी कोलकाता बना दिया देखो सेंटेंस किसको सुना है
And regarding finding, another finding is there regarding 17.
Yes.
Para 282 Lordship, page 1340.
280?
282. page 1340. Again, here also along with the other accused persons, finding is there. The prosecution side also have been able to prove beyond all reasonable doubt that the accused Golan Dolagapu, Jivangsu Pal, Kojendra Hojai, Babul Kamprai, so and so, so and so, so and so, after forming terrorist gang, DSDJ in 2004, directly, indirectly involved in collecting funds or attempts to collect funds by.
Same para has been lifted from that judgment.
Lordship, same. The day after, again, 283 para, your lordship can see. It is however correct that mere raising and collection funds will not satisfy all the ingredients of charge under section 1718 of the UP Act. One more requirement is knowledge of is also necessary. But having considered all the facts which the prosecution side has proved against them is totality, it cannot be said that all commissions or omissions have happened without their knowledge. The transaction amounts were also very high. The said amounts were defalcated from the government fund.
Can it be said that they happened without their knowledge?
No evidence at all, sir.
Okay.
Parvus finding, that is my submission also.
All right.
So my humble submission is no case has been made out against this Jivangsu Pal under section 120B or 17 of the UP Act. The witnesses I have already laid out to your lordship. So,
Any specific questions from the IO? You want to refer any evidence?
IO also I will put it out.
PW
128.
volume 6.
Volume 3. Page 696, directly come to prosecution part law.
690?
396. 696. The last portion, last para. Prosecution accused Jivangsu Pal. In the last week of December 2009, I was entrusted to investigate the NIA case number 2 of 09. No written order has been submitted before the court to show that I was entrusted to investigate the NIA case 2 of 09. Regarding taking up investigation of Bosista PS case number 170 of 09 and Dyungmuk PS case number 3 of 09 by NIA, that is mentioned in the FIR along with the enclosures. I have not personally seized any materials from Jivangsu Pal. Seizure was made by the Assam Police in Dyungmuk PS case number 3 of 09. The aforesaid seizures are in the court record of the court. I do not remember the name of the bank officials whom I examined in connection with the present case. No bank officials were examined also. It is not a fact that our expert has not opined the sex were encased by Jivangsu Pal is fictitious name. I do not know whether the accused Jivangsu Pal was acquitted in CBI case number 12/10 in connection with the present sex in question, and the aforesaid sex were also executed in the said case. I have not found any evidence that Jivangsu Pal was a member of banned organization DSDJ. It is not a fact that no money was recovered from Jivangsu Pal. It is also not a fact that Jivangsu was not involved in siphoning of government fund for giving to DSDJ. It is not a fact that Jivangsu did not encase the sex in question, which are marked as so and so. It is not a fact that I conducted an investigation in a perfunctory manner. It is not a fact that Jivangsu Pal was not involved in an unlawful. So this was the cross of the IO. And so for the sanctioning officer also, they have already the other council, they have already raised the same argument, lordship. It was not given within the 7 days time. So that cannot be accepted, lordship. And so for this accused person, under 25 Arms Act also sanction was granted. No connection with the guns. In spite of that, 25 also sanction was granted against me. So my humble submission.
Yes.
That he should be given the benefit of equitable law. So these are the evidence. Apart from these, other things are not there.
Yes. Gulam Dolagupu. Yes.
He was also convicted along with this accused person.
He was?
This person was convicted of the same section 120B and 17 of the unlawful activity. But the fact remains, my lord, he was a executive member at that point of time. Immediately he was arrested. His confession was recorded.
Confession was recorded.
It was a exculpatory confession, not an inculpatory. And this confession, though was in the list of documents, it was mentioned, but it was not exhibited in the court.
Not exhibited. Okay.
But I have a copy of the there. Your lordship can.
But then if it has not been exhibited, it's not relied upon. Then why should we read it?
IO said in their cross-examination that we have relied upon the statement, but
it's not exhibited document either. You should have exhibited
Yes,
If the prosecution, if you wanted to rely upon that, you could have admitted, exhibited it.
yes, my lord.
Otherwise, also a confession of an accused, what is the value thereof?
It's an exculpatory confession. That's not,
Now you
that's
come-
confession of guilt, my lord.
Come out with the argument, what is it?
Now, so far as the only day that they have evidence is coming the Caesar witness against me. That- Only man. And
Nothing.
and the Ram Prasad driver, that is the evidence.
That he has read. So yeah, all right, it was your vehicle in which the money was being.
Yes, my lord.
That's all.
That's all.
Were you an accused in the CBI case?
No, no, no. Simply he boarded the vehicle, my lord, near the railway station, and and thereafter Caesar took place. That is much. That's much only. Nothing much, nothing more than that.
Any evidence to link Mohit Ojai and you?
No, nothing, my lord.
Nothing.
Nothing. Because I was there, because they realized, but the prosecution did not deploy Hojai, Penal 105. In that meeting, my lord, since as a member of the executive council, I was also there. That
No,
much.
that's all right.
But I have no role to play regarding resignation, my lord.
Okay.
And secondly, my lord, just I like to draw your to the PW 128, my lord. That is
Yeah, you.
IO, my lord, the cross examination part. 640, 662 by law. It starts by law. Kadak Singh Thakur, my lord.
ये बंद कर दीजिए उसको. बंद कर. Yes.
I'm coming, my lord. That you'll also can be 695, my lord. The cross examination for accused Golan Dolaba. Near case 2 of 2009, I submitted charges on 19/10/2020. Then the sanction order exhibit 280 was issued by the Government of India Ministry of Home Affairs on 12/10/2010. On 29/2010, I forwarded my investigation report with enclosure to NIA headquarters, but in my case diary, there is no mention to the fact that when the NIA forwarded the request for sanction to the company authority to the Ministry of Home Affairs. In the charge sheet, in the list of documents, serial number 54, I relied upon the statement of Golan Dolakapur under section 164. I have gone to the statement of Golan Dolakapur recorded which is available in case record. On 11/2/2000, both Jigamansu Pal and Golan Dolakapur were apprehended and arrested on 12/2/2029.
Only significant thing is that Jigamansu Pal filed an application.
Yes, my lord.
Zimma application.
Zimma
Yes.
application for received money that he owes the money, where he learned court asked the IO to submit a report regarding Zimma of the seized money. As per our court order, the accused Zimma filed an application on 13/5 claiming Zimma of the seized money. In the charge sheet, I have not indicated
All right.
that I have collected any material to show that accused Dolakapur is a member of BSJ. During investigation, I have not collected any material to show that Golan Dolakapur was a member of BSJ. I remember though was a member of a political party. I do not recollect the name of any political party. It is not correct to say without any materials, I filed such against 2020. And it is a performance, and later on, if it is indicated case that investigation report was sent to government sanction order against. So that is the only, there's no much evidence is left now.
Yes.
And regarding the finding part, my lord, you are also kindly see
Finding.
in the judgment, my lord. 1317, my lord. One three one seven, you will also find.
Just hold on. Para.
It starts on para 249, my lord.
249. Yes.
That is 240 says on this dispassionate analysis of the evidence discussed about circumstances appearing as the accused person students were then paragraph 2 times facts and circumstances appearing as the accused person Golan Dolakapur can be recapitulated as under. Number one, he was caught red-handed at Tijori at about 3 p.m., 3:30 p.m. along with the accused Jigamansu Pal on 11/2/2009 while he was carrying rupees 32 lakhs 11,000 in his Scorpio vehicle. Though he stated that he was found in possession of the accused Jigamansu Pal supply of pipes yet same is not found to be plausible. He is a member of NSHE, is not Kazakh Hills Autonomous Council. Vehicle in which the amount was carrying was belonging to NSHE council allotted to him. He misuses the official position by using the official vehicle for carrying a huge amount of money without plausible explanation. That is the findings, my lord. So far as
And he has discussed the role of the other accused in this judgment. Mr. PP, why the evidence, why findings are recorded against other accused in this judgment? They are not facing trial. Okay, that's all.
And then regarding on the point of finding regarding 1718, my lord, 120B, my lord, there's they have paragraph 280, my lord. They have already named the accused persons of accused Nia 1, my lord. That is paragraph. Prosecution has well to prove beyond reasonable doubt. Accused Golan Dapako, Jibangsu Pal, Posendra Ozai, Babul Kemprai, Mohit Ozai, Jewel Galasa, Asinta Vaisa, Valanchan Chana, Srimati Malswami, Niranjan Hojai, after forming a terrorist gang in 2004, entered into agreement with R.S. Khan, Karuna Saikya, Joint Kumar Ghosh, Devasis Bhattacharya, Sandeep Ghosh, to do illegal act, to raise funds for terrorists by suffering common funds, to procure arms and ammunition, to wage a war, extort money, disrupt the works, cause conversion. Is of course true that the
All right, that is just the formal ranting which is going on in the judgment.
Yes, man.
Yes.
And accordingly, the accordingly accused persons named above name are convicted under 120.
Okay.
Then 17 also interestingly, you will also may kindly see paragraph 284, next page, 1341. It is argued by defense side, no knowledge could be attributed to accused persons. Submission considered in light of the facts and circumstances. Considering the materials on record, it is entirety. The submission is found to be bereft of merit. In result, we find that whole the prosecution is able to establish all the basic ingredients of charge under section 70 of the Unlawful Activities Act against the accused person beyond reasonable doubt, and they are convicted under said section of law. In earlier paragraph also, he has discussed about the paragraph 283, if your lordship sees, and paragraph 282 about the siphoning of funds regarding the other case. R.S. Gandhi and all, and also regarding the Social Welfare Department.
Yes.
And there are, and in paragraph 282 of summing up, they have taken into consideration the evidence of year 1.
Okay.
And regarding that, another important fact is that regarding the sanction, my lord. The sanction order that you will also find that there is exhibit valid sanction, there is exhibit 280, my lord, in volume number 6, 1232. The sanction order doesn't disclose the facts constituting the offense. And because under the PCA, especially there is a decision of the Supreme Court way back in 1979, Iqbal, my lord, where Supreme Court says that how to prove a sanction order, my lord.
Yes. Okay, very well. Give the citation.
Yes, I'm giving the citation.
Okay.
Because it has to be two ways. If the section discloses the facts, then the files should not be produced. If the sanction doesn't disclose the facts, there are files have been produced regarding application of mine. If the facts are there, that it amounts to application of mine. If the signature has to be proved, that is a two way of proving it. But in this case, the facts are found to be missing in the sanction order. So
Sanction
on
order
this
is
ground, the
exhibit-
sanction order is invalid.
What is the exhibit of the sanction order?
280.
280?
Yes, but 283, man.
Oh.
280, man.
Yes.
280, page number 1232 of volume number 6, my lord.
Yes, all right.
So in view of the whatever facts I've narrated above, my lord, that and this judgment also relied by Supreme Court later on, my lord, also. There is another decision that is 2014-11 SSC, my lord, 431, my lord. Though in under the PC Act, my lord, regarding grant of sanction, my lord, how to be proved, my lord, sanction order, that has been discussed, my lord.
Okay. Very well.
So in view of the infirmities in the judgment,
Mm.
as a nature of that, the evidence that has been recorded against the accused persons, my lord,
Mm.
absolutely there is no evidence
Mm.
that he was party to a conspiracy, my lord. And he has committed any offense under section 17, my lord. So, and he is entitled for acquittal, my lord.
Okay. Yes. Hmm. What is the argument, gentlemen? Yes.
My lord,
Carry on, sir.
initially, the charge sheet was filed against all the accused persons.
Mm.
And I have one as well as in and I have two.
Yes. Hmm.
And in NI2, addition of these two accused persons were there.
Hmm.
The evidence collected at the initial stage, my lord, it comprises the same set of witnesses. So,
Tell us who are the witnesses
yeah.
who named these two persons.
Exactly, my lord. So what happened, my lord? So the whole set of evidence, because Golondolagapo, your lordship will find, accepting the evidence that has come on record, that they have done hostile. But he was the executive member.
So that was the offense. Being a member of the executive. That was the crime.
That is what it has happened, but it didn't come on as evidence. So he was sitting in the meeting where the whole the conspiracy happened regarding the call of
There are two arguments now. One is being the member of the executive at that point of time is a crime. Secondly, working in the building where the conspiracy took place, that is also constituent of the crime. Where is the finding? To this effect, that simply because he is.
That's a fact, madam. What has happened, madam? Because all the witnesses were deposed before the IO, that this is what has happened. They have done hostile. That is why the judgment has come.
What can be done? They have done hostile. They have done hostile.
No, I'm not.
We can't retrieve that situation. No?
I'm not grumbling. I'm not grumbling over that, madam. I'm just saying
What?
that is what it.
What?
Because
What investigation has your IU done other than recording 161? What kind of scientific investigation was done? You are branding the witnesses turning hostile as a reason. What has your IU done? What you have done for that matter? This case was separated or was tried together. But the findings have been given against the accused who are not being tried in this case. Simply because of your prayer for convenience that we'll have to otherwise examine witnesses twice. This exercise was done. So only and only reason, nothing else. And that has vitiated the entire proceeding. Because you say they conspired with Mohit Ojai. Mohit Ojai is not an accused in this case. In NIA 1, is there a finding that Mohit Ojai conspired with Dolan Dolagup also? There is no finding. That he conspired with Jimanshu Paul. No finding.
No.
So he has been convicted in that case.
Only one part is there, madam, that what Dipola said that there was a meeting.
Yes. So what is the fault? The executive members can't hold a meeting. So convict all of them. Why only one? Because he was found present in the vehicle wherein 32 lakhs was there. Only reason. Any witness to say that Jibangshu Pal also had any contract with the council?
No.
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 So Jibangshu Pal is an independent man. He is carrying 32 lakhs with him.
Yeah.
How is that money connected with the Executive Council? NCHSC?
No, I understand that, but the only thing, what has happened, my lord, that again, lordship will kindly permit me, because that's not as on evidence, but that you also will discard it. What has been?
We are not discarding anything. You tell us what is there to discard.
No, it is not on evidence, because what in the meeting that was held by.
You are a senior prosecutor, sir.
That is what.
Please don't unnecessarily compel us to make comments.
My lord.
So whatever transpired in the meeting, neither you know nor we know.
My lord, that is it.
We are not bothered about whatever transpired because it is not a part of this record.
No, that is why, because that was initial, that was the link, that in the meeting that you do this and this and give us money. So that is why in this Dianmukh case.
You had the opportunity to fix them for forgery, fraud, everything. Why didn't you file a charge sheet for those offences? Even in the CBI case, there is no charge sheet for 467. 409, they have been convicted. Now, if we see that, how can there be a conviction on these allegations in this case? And supposing we acquit them, what will happen to that conviction of Mohit Ojai?
Yeah.
Could you not have tried Mohit Ojai and the other person, Karuna Saikia, for the offense under PC Act in this trial? Was it permissible or not? Section 8. It was. Why were you required to give the investigation to CBI? To prove your incompetence.
Coming to this case, but we have got the same set of evidence here. Same set as your lordship has seen it.
Same set. Tell us how many witnesses refer to the name of Golan Dolagupu.
Yeah, only this 3 and 4. There's 5 witnesses, they have said
Two witnesses pertaining to Caesar.
Caesar.
One is your IO who filed charge sheet. One is the guy who gives the sanction. Thereafter, meeting, the witness did not support you. So one man carrying a bag, he might be carrying vegetables in that. One boy. Who was that boy? Where is your investigation? Where is the investigation, sir? No, nothing. So what was there in the bag? From where the inference is to be drawn?
In the 313, my lord, he said that he is carrying pumpkin.
Yes, all right. You disprove that.
Because when he got up, when
he was carrying holy sand from Brahmaputra for all we know.
When the vehicle was, because Jivangshu was known to Golan Dolagupu.
Is that a crime?
So when he
So that is why Jivangshu said, all right, I'm carrying pumpkins, allow me. I'm going to the railway station. How did Golan Dolagupu know that Jivangshu Pal is carrying cash in his bag?
What happened? When he got up, that is what it came up under. What is in your bag? He says, I'm carrying some pumpkin.
Okay. So he knows.
Yeah.
He believed him. He might even have entered in the thought that he'll give me one piece for cooking in the evening. We'll prepare good vegetable soup.
And thereafter, when it was discovered that it amounts to cash, then he said that no, it is for purchasing some material at Guwahati for supplying it to so and so and so.
All right. So then what? Then what? So he did not give any indication that it is meant to purchase weapons for DSDG.
True.
True. So how do you presume in the FIR that this cash is meant for that purpose? That shows your preconceived bent of mind. How the report contains a recital to that effect. What about your fairness then? Question mark on your bona fides.
Only I can say that, my lord, that the presumption only that transpires from the meeting, my lord. In the meeting,
When the seizure was made, the IO did not know anything about the meeting. It is right?
they say it is a information that they had that he was, they are carrying this amount to be delivered.
Information you did not prove.
That is what.
That secret information is not there before us. There is no need to disclose the name of the informer, but the information can very well be proved. So now what is to be done?
So this, whatever we have seen the finding, matter that we have gone to your lordship, the finding.
And now, all right.
At least in Jivangshu and Golam Dalagopo, that we have seen it, madam.
What finding? Conspiracy.
No.
Inference to be drawn from what fact? Recovery of currency notes. That's all. So what exactly should be the amount from which we start inferring the conspiracy? Had it been a smaller amount, 2 lakhs, we couldn't have inferred. What is the yardstick, benchmark? कि 20 लाख होगा उससे ऊपर होगा तो मान लिया जाएगा जब DSDJ के लिए है ना ऐसा कुछ there is something in the law to that effect.
Because just because all the other persons were discharged, so now the evidence that has come, it has come in a very difficult way. And for I appreciate for the
What prevented you from challenging that order of discharge?
Yeah, that is for my client to say, client to take a decision, my lord.
You are the prosecutor. He is not a routine client. You are leading the case.
Not true, madam. We can only say that, advise them. For them to take a decision, madam. That is what.
Was there even an argument? We'll find out from that order that when those other accused were discharged, did you raise an objection? Don't do it, it will prejudice this case. Was there any objection by the state?
No.
No?
No.
Then
I don't think
then it's not a case of client giving the instructions. It's a concession by the prosecution.
that is what it has surfaced, madam. We cannot
All
say
right.
beyond that anything.
Okay,
madam.
we understand your
That may go-
difficulty.
That may go to.
We
different
understand.
stage, madam.
We understand your,
Madam.
but this has been a blunder, absolute blunder.
Madam.
Okay. Yes, Mr. TSJ.
Madam. Yes, sir.
Okay. All right. Arguments are generated. When there was one argument, important argument on sanction. What is your take on that? That the sanction order does not disclose the necessary ingredients of the offense. It should go on that only. Sanction is mandatory for UPAP. So if your order doesn't disclose the necessary ingredients of the offense, should we read it? Let's read it, Exhibit 283.
But what I would say regarding sanction here, madam, the sanction, already your lordship has gone through it, madam. The sanction in other cases, in CRPC, then in PCA.
There is more sanctity attached to those sanction orders rather than NIA.
But no, what is
Then
here,
here,
here the sanction is to launch an prosecution.
is to launch a prosecution.
Whether,
I'm sure. Let us see.
no,
UPAP.
whether,
Is sanction under UPA
but
or NIA?
that is, madam,
Sanction under what provision of law?
madam, that is section 45
Of the,
45. And therein,
so
madam,
let's see.
in PC Act on PC Act in.
Let's see,
than
let's see the language of the
CRPC.
Let's,
There we find,
let's see if, and find out if there is a difference.
yeah, it is the authority.
It begins with no court shall take cognizance.
Take cognizance. So it is not the same language as PC Act.
Section 19.
PC Act, there's a difference. That's right. There's a difference in intent of the section. This is just for the purpose of allowing the prosecution to proceed, not like section 19. That is a protective umbrella provided to the accused.
So that the officers, they work fearlessly in the result of
Yes,
the
you are right, you are right.
in the
I understand.
But here, being the terrorist act, my lord, it should not be that
It is
anybody.
basically a permission to file a charge sheet.
Yes.
That is the only thing which is required. A formal, a very formal act.
Subsection to your lordship, sanction for prosecution shall be given with so prescribed as may be within such as may prescribed after considering the report of such authority appointed by the government as the case of state government. Shall make an independent review of the evidence gathered in the course of investigation, makes a recommendation with such time as may be prescribed as the government as the case may be. But in the sanction order, your lordship would take, it only states that, my lord. Whereas in respect of FIR of the Yangon police station, case number so and so, so and so, so and so, so and so, whereas during the course of investigation, section 16, 17, 18, 19 of the unlawful activities were added. Whereas basically investigating also a short sanction prosecution, all the accused persons means total 16 accused persons. They sought prosecution. my lord.
True, my lord, because at that time they were there.
Whereas the government in terms of provision of so and so, so and so, constitutional authority referred to above mentioned case. Authority so constituted for purpose making independent review of the evidence gathered in the course of investigation. The authority after being satisfied on the material available on the record, on the facts, circumstances stated here, recommended sanction for prosecution. Now the cell government, in pursuance of section 196 of the CRPC, section 45(1) of the Unlawful Activities Act, after examination of material placed before the, having regard to the circumstances of the case and recommendation of authority, as mentioned above, the accord sanction of the prosecution.
So this order doesn't reflect that the sanctioning authority reviewed the evidence.
Yeah, that is.
There's no such a reflection in the order.
Because facts constituting offense is not missing in this. That is my submission.
Facts constituting the offense.
Yes, madam.
The order is silent on that. Okay, very well. We'll see. Yes. So the last date we posed the question.
Yes, yes. So
Is the tribunal functional?
Yes, madam.
It is functioning. Okay.
I would like to address on that and pursue the lordship on that. Might not be 46th amendment of the Indian Constitution brought in Article 323A. Now, Article 323A brought in the tribunals. May I refer to that constitution?
Yes.
Article 323A.
So this, Mr. Banik, this question, so far as disputes of central government employees are concerned, has been answered time and again.
There's a difference.
What difference?
If lordship allows me to pursue the lordship, I'll try.
Yes.
Now, the 42nd amendment, which was effective from 3/1/1977 of the Indian Constitution, part 14A was inserted by amendment. This was tribunals.
Yes.
May I just read the operative part?
You're reading to
No, I'm reading the Constitution.
Yes. Article
323A.
Yes.
Parliament may, by law, provide for the adjudication or trial by administrative tribunals of disputes and complaints with respect to recruitment
and conditions of service of persons appointed to public services and posts in connection with the affairs of the union or of any state or of any local body or other authority within the territory of India or under the control of the government of India or any corporation owned and controlled by the government of India. Now, this provides for constitutionally a state, a tribunal for the state. Once a tribunal for the state under 323A is brought in, then number 2, a law made under clause 1 may D. I'll go to D. With lordship is on. Exclude the jurisdiction of all courts except jurisdiction of the Supreme Court under Article 136 with respect to disputes or complaints referred to in clause 1. So the ouster of jurisdiction of this honorable court will bring in once a tribunal under 323A is brought in. So far as the Administrative Tribunals Act of 1985 is concerned, after the 42nd Amendment, this is the act which brings in the law. May I read the
Administrative Tribunals
Act?
Yes. Yes.
Before I read this act, I read the part in the italics, my lord. An act to provide for the adjudication or trial by the administrative tribunals of disputes and complaints with respect to recruitment and conditions of service of persons appointed to public services and posts in connection with the affairs of the union or of any state or of any local or other authority within the territory of India or under the control of the government of India or of any corporation or society owned or controlled by the government in pursuance of Article 323A of the Constitution of India and for matters connected therewith or incidental thereto. So this act comes in under Article 323A. Once it comes in, number 1, this act may be called the Administrative Tribunals Act of 85. It extends so far as related to Central Administrative Tribunal to the whole of India, insofar as administrative tribunals for the states to the whole of India except the state of Jammu and Kashmir. So this, after the constitutional amendment, this act comes in. The 80 for the state comes in, section 4 now. Section 4, 2, subsection 2. The central government may, on receipt of a request on its behalf from any state government, establish by notification an administrative tribunal for the state to be known as so-and-so name of the state administrative tribunal to exercise the jurisdiction, powers, authority conferred under 80 for the state under this act. The only test is whether the Assam Administrative Tribunal is under the 323A or under the Act of 85. The lordship would have the
Assam Administrative Tribunal Act
1977. This is created by an Act of 1977. This is not by a law flowing from 323A. Therefore, this does not lead to ouster of the jurisdiction.
Maybe,
Or conferment of jurisdiction.
is it an efficacious remedy or not?
It
That
is
is the
an
question.
appellate jurisdiction, my lord. It is an appellate jurisdiction. What I am on is that.
No original jurisdiction provided to the.
No, it's not provided. Not at all.
Let's see. Let's see. Let's see what kind of disputes
My lord.
the Assam Administrative Tribunal Act
My lord.
can deal with.
4. Section 4. Save as otherwise expressly given in subsection 2 below, the tribunal shall have jurisdiction to entertain and dispose appeals. Entertain and dispose appeals referred by civil servants against any order passed by the competent authority in any condition of service and pension matters. Notwithstanding anything contained in subsection 1 above, the tribunal shall have no jurisdiction with respect to any order passed when a civil servant has not availed of all the remedies available to him under the relevant service rules, executive instructions, orders.
Yes.
Pausing for a moment, as I infer, my lord, a tribunal constituted after the constitutional amendment under the Act of 1985 would and only would lead to ouster of jurisdiction of the Honorable High Court. It's not a doctrine of election. I don't have a choice. It is, I'm compelled to come to the High Court. This is an appellate tribunal. I may go there after I exhaust remedies under the statute. I may go there if I want to prefer an appeal. But if I want to seek fundamental legal rights, necessarily and invariably, I have to approach this Honorable High Court. What had fallen from your lordship was that the conditions of service which in the realm of which the administrative tribunal is, I bow down to that, but only in case of the appellate authority. not as a tribunal, unlike the Central Abyss Tribunal. That would be under the Act of 85. So distinction I have drawn, I presume.
But the appeal relates to
Appeal relates.
any condition of service.
True. Appeal relates to condition of service after I've exhausted my remedies under the Act. That is, I may prefer an appeal. It's not I shall prefer an appeal. I may prefer an appeal.
But tell us why it is not an efficacious remedy.
It was not an efficacious remedy for the purpose.
Why not?
Because I do not want to go to an appeal. After an
That's not your choice.
that is a matter of choice. Lordship was on the ouster of jurisdiction the other day, if I'm correct.
Yes.
The ouster of jurisdiction is gone. Once the ouster of jurisdiction of voice, it's not that I cannot come to High Court or I have to go there.
Yes.
Had it been so, all matters would have been relegated there. This is the first claim of argument, Miller. There is a concept, there is a case where there is a question of the promotion of a person to the post of principal under the rules of 2003. The crux of the matter is that the ACR, the annual confidential roll for 3 years were to be seen. I concede to the point for the 2 years, the reporting authority and the reviewing authority did not have a jurisdiction. But for the 3rd year, yes, they had. The Honorable Single Judge, going through this aspect of the matter, had passed an order for de novo selection. We preferred an appeal on the count that under the law, under the Assam law, it says, if the reporting authority has not seen me for 90 days, then the reviewing authority will give an act. If the reviewing authority has not seen for 90 days, then the accepting authority. And if none of them has seen me for 90 days, they'll put a remark on that. So on that count, 2 things can follow. A, under the law, they have to come up with a statement that de novo selection would be bad in law. You put a remark and then follow the law. Or 13 and 14 be restrict to. May I invite my lord's attention to the Assam Services Confidential Rules 1990. The Assam Services Confidential Rules, page number, I'm referring to 359. Serviceman.
359 or 259? 359.
Oh, yes.
Clause
358, 359. I'll refer to 358, clause 7. That is rule 5, sub rule 7. 358. If you're on the same book, may I read?
Yes.
Where the reporting authority, the reviewing authority, and the accepting authority have not seen the performance of a member of a service for at least 90 days during a period for which the report is to be written. An entry to that effect shall be made in the confidential report for such period by the government. They did not do that exercise. Rather, they urged for de novo selection. I concede, Miller, in all fairness, that 13, 14, and 15, 13 and 14, the reporting authority did not have the jurisdiction. The reviewing authority, inspector of schools, did not have the jurisdiction. I concede. So it could be a de novo selection in this view of the matter for 13 and 14. So for us 15, jurisdiction was there. No issues. We are on one page in that. But when I go through the Assam Services Confidential Rules 1990, sub rule 7, rule 7, sub rules, rule 5, sub rule 7, it takes care of a situation where no one is seen. So for 13 and 14, this is applicable. If that be so, in absence of a remark from the state authority, the error lies there. And on that view of the matter, perhaps the Honorable Single Judge heard in law. That is our case. Upfront, de novo may not come in way. It's for the government to show what they have done about it. I was a respondent in the writ petition, and the writ petitioner's case was, I got excellent, when he got good, that is okay. And then he says he did not have the jurisdiction, I concede. Now for the government to say, and records were called for from the government, the original records of the ACR.
So if neither the reporting authority nor the assessing authority put their remarks,
yes,
then it has to be a seal. Basically, it is a seal which is applied.
Absolutely, my lord.
Yes. So for that period, what would be the yardstick?
That is not spelled out. That is not spelled out, but possibly it might have come in, because if no one has seen, no one cannot see. Either you let it go for those 2 years, take the third. A logical corollary to that, my lord. They cannot time travel and see and then put the remark. But the original records with the government was called for. I rest my case.
So you say that the assessment should be made on basis of ACR for the year 2015 only.
One view, if I go by this, or at all if my lord goes for de novo, I have no choice. If lordship interprets this to say no one could see, then nothing can be done, then you go for de novo, then 13-14 only. I leave it to your lordship. But I would say it should be on the basis of 15 and 15 alone.
With 13-14 now, there is no one to write.
No one to write. But the seal is absent. They should put the seal, confine on 15, and they should.
Confine on 15, yes.
I rest my case, my lord.
Yes, please.
But I have got the record, original ACS of both the incumbent, my lord.
Yes.
But right now I am holding the Xerox copy of that, my lord.
It's okay. What's the problem? We believe that you are having the genuine copies.
Because that was somehow misplaced, my lord. That's why I have having
The original is misplaced.
because they have sent it, my lord, and they have sent in PDF format also, my lord. I got the PDF format, my lord. So
So original is there with the department.
yes, my lord. That is there at the department, my lord. But somehow it was misplaced. That is why I am placing the PDF copy, my lord.
Now this is a 13-14. He says that it is by an authority who was incompetent to put the
In charge headmaster, my lord.
in charge headmaster. So not authorized. So we consider it no remark at all.
Yes.
Yes.
So 2015 is there.
15 is there, my lord. Page number 18.
Make the assessment based on 15. What is the problem?
Yes, my lord.
So ultimately in 15 also, what is the assessment? The assessment for me here. In even 15, there is no opinion of the recording authority. No opinion at all.
Reporting, reviewing, accepting.
No opinion. Have a look.
I have not privy to that.
Have a look at this. So give him all the copies.
Yes.
Or you can have a look at the 15 on what you are relying upon. There's nothing. Have a look at it. What should it be assessed? There's no indication. What is the assessment made? Have a look at page 18. Good, bad, indifferent. There had to be some kind of recording.
Subject to correction.
A line has been put.
My name is Khairul Islam Lastor. And
Okay, this is
Anjan Kanti Nath.
Anjan Kanti. Okay.
I'm not Anjan Kanti Nath.
ये किसका लाया हो भाई?
I'm not Anjan Kanti Nath.
For petitioner, my lord, page 6.
Oh, you said it, page 18. I looked at page 18, that's why.
But here also same, my lord.
Same. Have a look at page 6, Ms. Kakati. Seems that these officers themselves need a different remark in their ACR. How to fill in a ACR. The recording authority, what he has done.
It did not travel to the accepting authority, that's all. The ACRs of 15 are valid, legitimately valid. It did not travel to the accepting authority. That's a department.
No. The issue is, what is the opinion? What is the
opinion is good.
Where is it?
Page 6.
Read page 6.
Clause
That
4.
is good.
Good.
Good on different components. What is the ultimate?
So
state of health good.
So far as the ACR state are concerned, with good, excellent, these are the terms they use.
So these are the terms. This is the reporting authority. Reporting authority's opinion is not relevant. Ultimately, it has to be the recording authority.
As I see now, my lord, so far as the accepting authority is concerned, it never
Recording.
traveled down.
A recording authority.
Reporting authority is there. Then it should be.
The reporting authority simply forwards what he feels like.
What he feels
like. But ultimate opinion has to be expressed by the recording authority or the reporting authority.
Reporting, reviewing, accepting. The accepting authority is blank, meaning thereby it did not travel there. The file did not travel there.
The reviewing authority is there.
Is there.
Nothing. Opinion.
Then it is confined to 2015 only, my lord.
This is 15.
De novo 15.
De novo 15. Yes.
De novo 15.
What do you say? What the learned single judge has directed?
My lordship. Entire de novo.
De novo for all three.
For all three. Page 17.
So why not for all three? What is the hesitation?
All three would not come in.
Why?
For essential fact that the reporting authority or the reviewing authority were incompetent then. Applying 7.5, even the government cannot go back and see what was doing where. Therefore, in all fairness to both, let 13-14 go. Equal for both, 0-0 or 100-100.
But then the exercise requires ACRs of 3 years.
Exercise requires for 3 years, but it's a classic case where of 2, we have a situation of a stalemate. Nothing can be done. We cannot make a move. 3rd year is valid. We go by that. It's equal for both. Even if a de novo for 3, 2 have to go. Those 2 has to go, below. Invariably has to go.
Lordship, may submission. Lordship, in this case, even for the 2015 may not be taken into consideration.
That's what he says.
Yes.
Let there be a fresh consideration of 2015 ACR and then let the promotional exercise be undertaken on the basis of the 2015 ACR. But there must have been subsequent 2 years also.
It's lying that way only. Nothing
that way, nothing thereafter.
Lordship, the principal IC who has written the SCRs.
For 2013-14, that he also doesn't challenge that fact.
And Lordship, the another fact is there. Is the principal IC was also the candidate of the principal.
He agrees 13-14, he doesn't go into that. He's not challenging the finding that the authority was incompetent. But he says that have a proper exercise be undertaken for the ACR of 15 for both. Let there be an opinion and then based thereupon you proceed for the selection process. What is your statement on that? What is your stand on that?
And Lordship, as per the order of the director, the ACR has to be taken for 3 years.
What 3 years now? How can you go back in time? Because there is no reporting authority.
Yes.
Who will make the report? At least for 15, no reporting authority, meaning thereby the incompetent reporting authority. For 15, at least we have the appropriate reports on record.
Yes.
Let the recording authority and the reviewing authority give their opinion and base thereupon go for the promotion or selection. What is the other mode available?
So 15 will be the de novo, Lordship.
Yes, 15 de novo. He doesn't. 15 rather there is no opinion again, as we see. So it has to be a de novo exercise from the stage of recording and reviewing, or rather only reviewing.
Reporting has been done, reviewing and accepting.
Reviewing and accepting.
Reviewing, accepting.
Lordship, the one issue is there because the principal IC was also the candidate for the post of the same post for the school
In 15 also.
Yes, because she was also the candidate. So she raised the ACRs of the appellant and the rest number 6. So
So now who will make the report, sir? Now,
the lordship as per the page 39 lordship is made. Can you look into
39.
39 lordship? This is the order of 23rd June 2016 issued by director lordship.
Yes.
The column lordship integrity, point number 3, ACRs of the last 3 years by the inspector of schools. So it should be by the inspector of schools lordship.
Inspector of schools would not be the accepting authority. For the post concern, inspector of schools would be the reviewing authority.
Reviewing authority.
Reviewing authority.
So accepting authority would be the director or deputy director?
Director, right?
Where are you reading the inspector?
Is it page 39?
39.
3. On the extreme right hand column, 3.
Integrity 5 marks.
Integrity 5 marks. The last part, number 3, ACR of the last 3 years by inspector of schools.
So for principal, the inspector can only be the
reviewing authority.
Reviewing authority. But for that period, if the accepting authority is not there, then they'll have to put a seal.
They'll put a seal.
That's it.
They'll put a seal. That's it.
So let the inspector make a review ACR, review of the ACR, whatever statistics is available. Let the inspector decide.
Lordship.
And then the accepting authority is not there. There'll be a seal. So whatever the reviewing authority has said, that will be the
Lordship.
ACR for the year.
My lord.
Lordship, my only point is this, that the principal IC has, in my ACLs in the 3 years, she has given a remark of good marks. Good is the lowest, Lordship. As because she was also the candidate for the post of the principal.
So he also stands in the same page as you.
Yes, Lordship.
So we have to give that at least for 15. Who was the reporting authority? Who has made the reporting in 15? Same principal.
Same principal IC, Lordship.
In charge.
I see.
In charge.
Inserts and Lordship.
What I am submitting, my lord, de novo 2015, whoever is the jurisdiction authority.
All right. The entire exercise. Let it be the entire exercise for 15.
15.
How you will be able to do it? How you will be able to do it for 15 now?
By the inspector of school, my lord.
Inspector school.
That is the only option, my lord, because all of them are the incumbents.
All right.
Appeared in the, my lord.
So, all right, we'll pass the order that the review ACR for the years 2015.
15.
Why not for all 3 years now then? Let the inspector do for all 3 years. If you are doing it for 15, because the rule says consideration can be made after 3 ACRs only.
There would be a difficulty, my lord.
Why?
Because of the confidential rules. If a gentleman has not seen me for 90 days, it passes on to the higher one. Again, we come back to the stage when the seal has to be put. 15
higher
one
one
was there, the inspector schools was there, 15 de novo is good enough.
So 15 also 90 days has crossed. Same way, if we find that the reporting authority is incompetent, then for 15 also the things have crossed totally.
But the inspector of schools,
yes,
who was holding the post,
who was, we don't know whether he is there now.
No, he may not be there.
Then,
but for the ACR, that can be done.
So then let it be for all 3 years. So the mandate of the rule is compliant.
But so far as all 3 years, the difficulty would be subject to correction, my lord. If the 2015 is taken, gentleman who was holding the post there as a reviewing authority had seen both of us working. So he's competent to write. But so far as 13, 14, there is no one.
For all we know, the same officer may not be here, not be on the post now. So who has seen whom? We don't know.
If he's not holding the particular post, it would still be sent to him for writing the ACR of these two. When, as and when
we don't even know whether he has superannuated in the meanwhile.
Let him get back on the next day as to that.
All right, you find out if the inspector who was working at that particular point of time, if he is available, that will give rise to a very subjective consideration. The inspector will be very glad to receive favors then. You just think over that.
I believe in the rule of law. I believe things would go properly.
Very well. Let's see.
Obliged, Lordship.
List on 13 June.
13 June. Very good.
Eva. You return this to comment on. Very strange.
Item number 19.
Ismail, Mr. Banik has addressed the court on the query made by order dated so and so. He urges that as the Assam Administrative Tribunal constituted under the Act of 1977 is constituted under the Act of 1977 as an appellate authority, and since the same is not constituted under Article 323A of the Constitution of India, there cannot be any exclusion of jurisdiction of the High Court, and hence, the writ petition jurisdiction, the writ petition is maintainable to entertain such as service dispute, irrespective of the fact that the parties concerned did not approach the tribunal for ventilating the grievances. In view of the submission noted above, the court proceeds. The parties shall not be non-suited on account of the availability of the alternative remedy. Okay. Yes.
My lord,
This is item number 9.
my lord, before my learned senior counsel submits, my lord, may I submit one thing? My lord?
Yes, please.
I'm response number 1, my lord. I'm led by senior counsel TJ Mohanta. So he has informed, my lord, he is having some illness, my lord, he has left, my lord. So
what do you say, Mr. Das?
I can't oppose it.
A request is made to adjourn matter on behalf of lead counsel, Mr. TJ Mohanta, who represents the respondent number 1 in this writ appeal. Mr. Das does not object to the prayer for adjournment. List after. Then it goes to after summer vacation now.
Well, let it go.
After summer vacation.
I want to cool off during the summer.
Yes.
This
It's
summer.
a better idea.
It's telling upon my health.
Yes, yes. It's really very warm.
Excellent.
Okay.
Much obliged.
Item number 20.
Yes, please.
May I please, Lord? Here, that the root of the cause of the case, my that Lordship will find this honorable court, the single bench order, my lord, at pace 111 minute. 111 minute. For understanding, just I'm coming to the root of the case. The order on 3/5/2017.
Lordship married. Heard Mr. So-and-so, learning counsel for the petition, also heard Mr. So-and-so, see what is it, learning counsel for the council education secondary department, appearing for the respondent number 1, 2, 3, and Mr. K. Fukan, learning so-and-so.
So
The
the
petition-
composition of the selection committee
Lordship.
and qualification,
Yes.
both are under challenge.
Yes.
Okay.
But here, that the petitioner is a B.Ed degree holder and is also presently the in-charge principal of AKH institutions. Mr. Sethi submits the reference to paragraph 10 of the writ petition that the selection committee for selection of the principal in respect of AKH institution was not in terms of the rule 8.4 of the Assam Secondary Education Provincialization Service Rules 2003. Inasmuch as instead of the vice principal a postgraduate teacher in the case of higher secondary schools, AKS institution is a higher secondary school. As a member, the vice president of the school management and development committee was inducted as a member, and therefore the same goes to the root of the matter. Mr. Bhattacharya praised for the some time to obtain instruction. Till then, the petition shall continue as principal in charge of the institution. Now next order, Lordship will find page 112, Lordship. That order was passed on receiving of the instruction, Lordship. That is, order was passed on 11/5/2017, madam. Heard so-and-so, and also C. Bhattacharya, Learned Standing Council, so-and-so Education Department, appearing for respondent number 1, 2, 3, and
Which order are you referring to?
Lordship.
Which are the order you are referring to?
No, I'm reading this.
Impugn order.
No,
Then
I'm just initially the honorable court passed the order on getting the instruction from the government.
at what page?
There was a totally violation of the rules, my
Where are you reading, sir?
Lordship. Page 113, Lordship. 113. 113, Lordship. Starts, the order starts from 112 and relevant portion 113.
This is the earlier round of litigation.
Yes. Now,
Yes.
now Lordship will find the subsequent in the 114. Mr. Bhattacharya in his submission today has not disputed the composition of the committee as referred to in paragraph 10 of the writ petition. He, however, submits that the respondent number 7 had joined in the office of the inspector of schools on 3/5/17. It appears prima facie that composition of the selection committee is not in conformity with Rule 8.4 of the Assam Secondary Education Provincial of Service Rules 2003. Issue notice so-and-so, no formal steps so-and-so, and they are duly represented. However, extra copies of so-and-so steps for service of notice on respondent of 5/6 by registered post. Till then, the petitioner shall continue as in charge headmaster of the AKH institutions. This is principle. My lord. Now, my lord, then Lordship will also find the selection at page 1116, 116, Lordship. The selection was made to 3 persons, my lord.
Yes.
Banikanta Chakravarti, number 1, and Puravi Das Bharali, and number 3 has been put to the appellant, my lord, Charulata Kolita. Now, Lordship will find in the select list itself that second one, Vice President SMDC, he has put his signature. My lord, Lordship will find in 117, that is in.
Yeah.
He has put the Vice President cannot be the member of the
SMDC
selection committee as per the rules.
Okay.
And he has been put as member of the selection committee.
What is the composition, please?
Composition, Lordship will find. I've stated in my para, my lord, para 10, Lordship, of my writ petition, my lord, Lordship will find.
Just make an oral statement as per you. What should be the composition?
Composition is, my lord, chairman will be the SMDC president, school management committee's president, and the secretary, the member secretary will be the the vice principal vice principal. And in the case of vice principal is absent or it is not there, then the inspector of schools, as per the order of the director, inspector of school has to notify that postgraduate teacher having MA, BEd, or if not, the master degree has to be notified, my lord, to be appointed as or inducted as the principal, the member secretary of the selection committee. That is not there, my lord. That this honorable court in earlier occasion has found that this, as per this government's order, director's order, my lord, that notify has not been made by the inspector of schools regarding the induction of secretary, this member secretary, since the principal in charge of that institution at that moment, my lord, was the candidate of the selection committee, my lord. He also appeared in the interview, that is Banikanta Chakraborty. So, my lord, that part is also missing, and the Rupak Deka, who has been, who was the vice president of SMDC, he has been inducted as a member, my lord. And thereby whole the selection process vitiated for violating of the statutory provisions of this rule. And this member secretary also not been notified.
Mr. Chetri,
Lordship.
but the order reads that in the meantime, the state selection board has made the selections of the respondent number 7. No. Read para 8.
Para 8 of Lordship.
Of the order, impugn order.
Learned Council for the Business Submitted the Rule 8.4 in question lays down the constitution of a school committee referring to Rule 8.4. Sri Chetri, Learned Council for the.
It may be mentioned here that in the meantime, White order dated 2/5/17.
8. It may be mentioned that in the meantime, the White Order 2/5/17 issued by the Director of Education, the respondent number 7 was appointed as principal on regular basis. The school in question pursuant to the recommendation of the State Selection Board, Assam. The said order has been brought on records by the petitioner by an additional affidavit filed on 3/5/17. Well, there are two phases of selection, my lord. One, it will go from district level, my lord. And after moving from district level, it will go to the government level, state level. And state level will approve accordingly. And now, of course, my lord, for your lordship's information, the since as per the rules 2003 amended 2012, my lord, it was the chairman was to be appointed as to be appointed from the SMDC presidents. Now, and the member secretary from either vice principal or the postgraduate teacher. Now, in 2018, the rules, it has been totally because of this confusion and the contradiction and some complaint have come. Now it has been made a rule like this. The president, the district level selection committee chairman will be the deputy commissioner, and the member secretary will be the inspector of schools. Now it has been totally changed. So the other teachers may not have any grievances since it would be done as per the merit of the case. Now here, my lord, here I have the stated, my lord, in the order, my lord. It has been reflected, my lord, para 6, my lord. Coming to the issue in question, an advertisement was published on 9/6/2016 for selection for the post of principal of the school in question. Such selection are required to be held by following Rule 13 of Assam Secretary Education Service Rules 2003, hereinafter referred to as rules, read with the guidelines laid down by the Director of Secondary Education dated 23/6/2016. The interview was held on 8/11/2016, and after such interview, the matter was kept pending at the level of the department, and it is the case of the petitioner that she was not aware about the outcome of the selection held by the selection committee. In the meantime, as has been stated earlier, the in-charge principal had retired from service on 31/3/2017, and the petitioner was allowed to hold the charge of the post of principal. It may be mentioned that the school selection committee constituted of the following members: Chairman Dr. Kukul Borua, President of SMDC; member Sri Rupak Deka, Vice President of SMDC, which is totally illegal one. Member 1, parent to be nominated by SMDC, and member secretary Binapani Mohanta, the subject teacher. Here, my lord, now Lordship will find the petitioner apprehends that since she had raised her voice regarding certain anomalies in the school fund, the school managing committee was against her, and therefore she was not treated fairly in the selection. The projected case of the petition is that on 18/4/17, she came to know that the respondent number 7 was selected for the post and was going to be appointed on so and so 2/5/17. According, the petitioner had submitted 2 representations dated 19/4/2017 and 24/4/17 respectively to the deputy commissioner and the inspector of schools. She had further submitted representation on 25/4/17 to the commissioner and secretary, government of Assam, as well as director of secondary education Assam. This court, while entertaining the repetition, had passed an interim order on 3/5/17 that the in-charge arrangement of the petitioner as principal would continue. Here, my lord, para 9, my lord. Mr. So counsel for the petitioner submits that the rule in question lays down the constitution of the selection committee, referring to Rule 8(4). The learned counsel for the petitioner submits that the chairman of the selection committee would be the president of the managing committee, followed by the members, one being from the faculty of the school, as indicated, and one parent member of the nominated by the managing committee. And the role of the member secretary has to be played by the principal headmaster of the school. For ready reference, the relevant provision of rule is quoted here in below. 4. The school selection committee for selection of principal, postgraduate teacher, graduate teacher, and non-teaching staff of school shall be as follows: the president, chairman, the president of the managing committee; member, the vice principal; a postgraduate teacher in case of higher secondary school, or assistant teacher or headmaster, senior most graduate teacher in case of high school. And 2, one parent to be nominated by the managing committee, and member secretary, the principal or headmaster of the school. And since the principal or principal in charge was the candidate, so naturally, as per this, the order of this director of secondary mallet, since it has been already reflected in the honorable court's order on 25/4. What again? Lordship will come to the honorable court's order of this honorable court matter, that is 25/4/2019, Lordship. Hard makes so and so, and since the contention Since the contention has been urged by the learned counsel for the appellant that the selection committee was not constituted as provided under section 8, under rule 8(4) of the Assam Secretary Provincialization Service Rule 2003, a consideration on that aspect would be necessary. Though at the outset, it is pointed out that the absence of the principal as the appellant himself was a candidate. The remaining 3 members provided under the rule had taken part in the process. In that regard, it is seen that the order dated 15/6/2016 provides that if the principal himself is a candidate, a postgraduate teacher having master's degree with B.Ed or a senior-most graduate teacher having master's degree with B.Ed is to be notified to be the member secretary of the member secretary, and since prima facie we find that the same has not been adhered to, the matter would require consideration in this respect. So, my lord, the rule itself, my lord.
Rule has been quoted.
2003 lordship.
Rule is quoted in the judgment.
Lordship.
Rule is quoted in the judgment.
Yes, yes,
Subclause 4,
yes,
8(4).
yes.
Yes.
And now. So only regarding this, the composition of as provided under the rules of 8(4), that was not complied with. And secondly, my lord, when the principal or the principal in charge is the candidate of the institution or the school, my lord, then the inspector of school has to notify that who will be the member secretary of the selection committee. That part is not there, my lord. They are totally vitiating all these provisions.
Who acted as the member secretary?
Now,
Some subject teacher.
one subject teacher has, and since they have stated in their affidavit, my lord, that the Binapani Mohanta, she was inducted as member. Again, she has also inducted as member secretary, my lord. How the two role can be played by her? And regarding the Rupak Deka, they have come with the affidavit saying that the Rupak Deka is only the facilitator member. There is no provision at all to get the membership or to induct as a facilitator member, my lord. And he cannot, has he been the facilitator member outside of the selection committee, how he will sign in the selection committee, which was the mark has been given, he has signed. But that cannot be done, my lord. And that's totally violation of the rules. And since in such cases, this our honorable court very well decided in the matter, my lord, that once it has been admitted that rule has been violated, that cannot be continued. And this liable to be struck down. Let there be a fresh interview, let there be a fresh selection, so that deputy commissioner is the chairman, and the member secretary is the inspector of schools. Let there be a fair selection. Since the whole selection based on the illegality cannot run, my lord. And if it is continued, my lord, then in next, it will be a of the court's order, my lord. So only
says that you participated without raising any objection.
Yeah.
What What do you have to say that about that?
My lord, since your lordship is aware, my lord, unless and until this appellant would have appeared in the interview.
She could not have known
Yes, I could not have known about the
composition.
composition, my lord. And that part in several judgment, lordship aware that in several judgment of the Supreme Court or our High Court has said that unless and until the persons appeared and know about this interview who are there, the composition cannot be in knowledge. And once it has come to the notice of the Honorable Court, now the Honorable Court will consider that aspect. And they say that as per this, when the composition and when the rule is itself is in violation, court cannot be stopped to pass order to go on merit and to regarding consideration to that aspect that there is a violation of the rules.
Okay, yes.
And to that effect, my lord, we have also the judgment of this Honorable Court, my lord. My lord, 2015 3GLT, my lord. 211.
Yes.
This is of single bench, my lord. This is Bonasri Bharadas, my lord. That
Yes.
this is para 17, 18, 19, my lord. Regarding Stoppel, my lord.
Yes.
And my lord, regarding this division bench of this Honorable Court, my lord, 2017, my lord,
Yes.
3GLT 429. The only I have one copy to apply. Send.
Yeah, we are having it.
Yes. But I want to reading out this para 4, my lord.
Yes.
4, 5, 6. Section 15A, 1A of B, NNB, subclause B of Guwahati University Act 1947, in short act, deals with the constitution of selection committee for making recommendation to the executive committee for appointment of professor, readers, etc. The relevant extract of section 15A, 1B of the act reads as under. 15A, selection committee. B, in making recommendation for the appointment of professor of the university, the selection committee shall co-opt the head of the department concerned. If he is a professor, one professor of the department to be nominated by Vice Chancellor, and 2 persons not in service of the university to be nominated by the Executive Council out of panel of not less than 5 names of persons recommended by the Academic Council who have special knowledge of the subject for which the professor is to be selected. A bare reading of the above quoted section 15A 1B makes it clear that in making the recommendation for appointment of professors of the university, the selection committee shall co-opt the head of the department concerned. If he is a professor, one professor of the department to be nominated by the Vice Chancellor and 2 persons not in the services of the persons university to be nominated by the Executive Council, and out of the panel of not less than 5 names, a person recommended by the Academic Council who have special knowledge of the subject for which the professor is to be selected. Now 6 is an important matter. Admittedly, in the case at hand, the selection committee was not constituted in terms of the section 15A 1B of the Act, as the Vice Chancellor himself nominated 2 persons as members instead of calling for the nomination of such 2 persons by the Executive Council. Section 15A 1B of the Act clearly states that Vice Chancellor is to nominate 1 professor of the department, whereas Executive Council is to nominate 2 persons who have special knowledge of the subject. The role of participation of such expert is crucial in the selection process because it is expected from the selection committee to make endeavor to select the best suitable candidate. Section 15A 1B does not permit the Executive Council to delegate its power on the Vice Chancellor to nominate two persons who have special knowledge of the subject. Therefore, the nomination of such two persons can be made only by Executive Council and not by the Vice Chancellor. It is well settled principle of law that statutory power must be exercised only by the authority or the person on whom it is conferred unless the statute by express words or necessary implication permits delegation. From the language used in the section 15A 1B also, it is apparent that requirement of nomination of two persons by the Executive Council from the panel experts is mandatory, which the learned single judge has rightly held by giving cogent reason in paragraph 31 of the order. There is yet another settled principle of law which says that when power is given to do a certain thing in a certain way, the thing must be done in that way and not at all. In other words, if the manner of doing a particular act is prescribed under any statute, the act must be done in that manner and not at all. Therefore, in the constitution of selection committee, even this principle of law was violated by the appellants. We are however, unable to agree with the learned single judge that the Vice Chancellor could have nominated the reappointed professor of the department in the selection committee. According to the learned single judge, being a member of the selection committee does not amount to holding administrative post. As per Rule 8C of the Guwahati University Teachers Re-employment Rules, a re-employed teacher cannot hold administrative post in the university. The Supreme Court in National Institute of Mental Health and Neurosciences versus Dr. K. Kalyan Raman, 1992 Supplement to SCC, has clearly held that function of the selection committee is neither judicial nor adjudicative and is purely administrative. Therefore, having regard to the decision of the Supreme Court, the Vice Chancellor cannot nominate a reappointed professor as a member of the selection committee. Be that as it may, we are of the considered view that since the selection committee was not constituted as mandated in section 15A 1B of the Act, its recommendation cannot be permitted to be acted upon. Subject to our findings in paragraph 7, we find no merit in the appeal. It is accordingly dismissed. My lord, and thereafter, my lord, Lordship also find.
Yes.
Yes. Lordship also find in the judgment, my lord, of the Honorable Supreme Court, my lord.
Citation.
2019.
Give it.
I have one more copy, my lord.
You could have given the list in advance, sir.
Yes. 2019-20 SCC. Attached. Page 17.
What is the principle laid down?
The relevant portion, my lord, from para 15 to 19, my lord.
And that is against regarding estoppel.
Estoppel, yes. There cannot be estoppel, my lord, to challenge the selection process after having been held in it.
Yes. All right. Okay.
Yes. This 15 to 19, my lord.
Okay, very well.
Then, my lord, Lordship will find the Krishna Rai, my lord, 2022, my lord. 8 ACC, 8 ACC, 713, my lord. This is also regarding estoppel, my lord.
Yes.
Para 23, my lord.
Read, please, read. You can read from the judgment.
Yes.
Yes.
However, the division bench fell in error in applying the principle of estoppel that the appellants having appeared in the interview and being unsuccessful proceeded to challenge the same, and on that ground alone allowed the appeals, set aside the judgment of the learned single judge. The division bench having approved the reasoning of the learned single judge ought not have interfered in the judgment of the learned single judge on a technical plea. The division bench ought to have considered that the appellants were class 4 employees working from 1977 onwards and expecting from them to have raised serious objection or
So that's a distinction in that judgment. They were class 4 employees.
And my lord, since some of the judgment they have relied on, here it has relied on, including the Madan Lal, saying that the Madan Lal cannot be applicable here. And other judgment, my lord. So, and this para 15 to 34, my lord.
It's a distinction in that judgment, Mr. Chetri. Yes. You concluded? Your arguments are done? Yes. Something more to say?
Yes, my lord, one judgment, my lord, that is.
On what issue?
My lord, the issue is composition of selection. My lord, this is a single bench judgment, my lord.
No, you already cited as division 1. Don't multiply.
Yes, yes.
Okay, very well. Yes.
Single bench judgment in 2003. And single bench judgment, we have 3 or 4 cases I have found.
Okay, very well. Yes.
If necessary, lordship.
All right, give the copies. Welcome.
Lordship.
Yes. Mr. Advocate General, you are appearing in this case?
No, lordship.
Okay.
Just before rising, I would like to make a short mention, lordship.
All right. Okay. Yes, Mr. Botakur. Yes.
Lordship, so far as the I am for the lordship candidate selected.
Composition of the committee. If how the candidate knows it before participating.
Lordship,
is it advised that this will be the composition?
Lordship, the honorable single judge, your lordship, not dismiss the petition on that ground, your lordship. If your lordship comes to page 20, para 20.
It has been dismissed.
That is your lordship.
On this very
my
ground.
Submission was that, your lordship.
Read para 20. Oh, what is this finding? There is not even a whisper regarding violation of rules of constitution of school selection committee.
Lordship.
The composition is there, rule is there. What is to be seen? What whisper is to be made?
Lordship, page para 20, your lordship.
Yes, we have read the para 20.
Lordship, the reading of the writ petition notes so that as regards the first ground of challenge from on the date of interview.
Forget these findings. You tell us, Mr. Bot.
Lordship, the honorable single judge, your lordship, while
you just tell us, was the committee composed as per the rules?
Lordship,
simple question.
Your lordship, so far as the affidavit of the school's managing committee is concerned, they have clearly stated, your lordship, that this person, your lordship, whose name they have mentioned, he has not given the marks, your lordship.
That is not relevant.
No,
if he was a part of the committee, the subjectivity set in. Plain and simple. The illegality corrupted in the very composition. He, without giving marks, was in a position to influence other people. That is the apprehension in the mind of the candidate.
That what your lordship is taken care of in para 20 by saying that your lordship, the marks are given on the basis of the objective criteria, your lordship.
Absolutely. Why composition was diluted or why it was tempered with? Why the composition was not as per the rules?
No, your lordship, they say, your lordship, he has not been included as a member, your lordship. He has been included as a facilitator, your lordship.
Oh,
That
does
is-
the
that is-
does the
that is
meeting,
their statement,
do
your
the
lordship.
minutes of the meeting
And
say
then
so?
your lordship will kindly note one aspect, your lordship.
Yes.
I was not this initially selected candidate. My position was second, your
We
lordship.
are not bothered. We are not bothered. When the challenge is made on the ground that the selection committee by itself is being constituted against the rule, then where is the question of upholding the decision of such committee?
No, your lordship will, at the same time, your lordship will kindly note, your lordship, that at no point of time, if your lordship comes to, if your lordship comes to.
Estoppel.
No, your lordship will come to page 49, her representation, your lordship.
Yes.
And your lordship will kindly note your lordship.
Immaterial. She realized later that the committee was not formed as per the rules.
Immediately
Can it
after-
save? Can it save the proceedings, sir?
No, your lordship, at in no point of time he has raised that grievance.
Oh,
And your
all right.
lordship- your-
This argument was raised in the writ petition.
Which your lordship?
Whichever year.
No, yes, your lordship, we have your lordship pointed out that in none of the our representation she has raised this point.
In writ petition, this argument has been raised.
Yes.
Or not?
lordship.
Representations to whom? Were the persons to whom the representations were made in a position to cancel the selection?
Your lordship is the director, your lordship.
Whether he has a,
And your lordship will kindly note another aspect, your lordship.
Yes.
Apart from, there are two tier of selection committees, your lordship.
yes,
One, your lordship, is the school level selection committee, then it goes to the. state
the
level selection-
recommendation of the SDMC, SMDC goes to the
State level
SSB,
selection committee.
SSB. So
No.
if the recommendation is vitiated, how the main selection by,
Lordship will kindly note, your lordship, they have not, she has not even raised that before the school state selection committee, your lordship. Now, your lordship.
what is the criterion? All right, tell us, what is the criterion adopted by the SSB, State Selection Board?
That your lordship will be able. to
Yes,
share
Mr.
by
Counsel,
the-
Mr. Katniar, what is the process before the SSB? Does the recommendation of the SMDC have any bearing in the assessment by the SSB?
No, my lord. Normally they look after the records of the selection. They regarding the
The
competitive.
marks are given by
Yes, my lord.
the SMDC. Do they count in the state? They must, obviously.
Yes, Lord, they look into the comparative statement.
So that evaluation matters. If evaluation is vitiated, the entire process is vitiated. What do you say on the composition part?
There are the rules are not followed, my lord, while
Chapter close them.
So your lordship will kindly see one aspect, your lordship, that your lordship, the para 20, your lordship, of the honorable single judge judgment, there is no there is no question of being subjectively satisfied to award marks, your lordship. It is based on your lordship. a
If the
particular-
composition is bad, it is bad irrespective of the fact that the marks were awarded by that member or not.
And
He
second,
was an influencer. Now, you know that is a new term, social media influencer.
lordship, that's-
He was an
those
influencer.
influencers are there, your lordship,
So-
but your lordship, so far as this is case.
So
is
that
concerned,
concept was perhaps
No, your
mooted at that point of time.
But influence will come, your lordship. Had I been selected at serial number 1. Now,
Immaterial.
see the situation, your lordship.
She is not bothered. She has been left out, so she feels that there was an influence.
No,
That's
your
all.
lordship will kindly see, I am in the second position. I would not have got the position, your lordship, had in the meantime this petition, this serial person selected at serial number 1 got retired, your lordship. It is by chance, your lordship. Therefore, your lordship, there is no question of bias also, your lordship. And there
Okay.
is no allegation.
There's a
of
question of unconstitutionality in composition, irregularity or illegality in the constitution of the committee. So even supposing this was brought in as a writ of certiorari, this court would have interfered. Had it been a PIL, this court would have interfered. There are dozens of instances.
Lordship, that is there, your lordship,
So
but
that-
only one thing, your lordship. So far as this person is concerned, your lordship, that your lordship, he has been there, your lordship, but he has not, I have made a specific amendment, and your lordship will kindly note why she has not raised this issue immediately thereafter. This is because your lordship.
Does it preclude her from raising the issue regarding gross illegality in the selection in the red court for the
That
first
is
time?
clear, your lordship, there is no gross illegality, your lordship. In
Gross-
sense, your lordship.
the composition-
Had she been aggrieved, your lordship, first thing she would have done, your lordship, to raise her finger and point it out to the authorities concerned.
Maybe she got wiser by the time.
No, your lordship will kindly see, it is for the first time in their writ petition. in
Yes.
her writ petition.
How many years after the selection that the writ petition came to be filed?
Lordship,
What is the time gap between the filing of the writ petition and the selection process?
selection process, your lordship. means,
What is the
after
date?
around
Date of the meeting of the
Your
selection?
lordship, around 6 months. your
6
lordship.
months. So
6 months, your lordship.
how can you say that her claim is belated.
Your Lordship, no, I am not saying claim is belated. What I am saying that she has not been agreed.
Would that cure
And
the
there are
illegality,
judgments, Your Lordship.
Mr. Counsel? Would that cure the illegality, please? Simply because she did not raise that objection in the before the commissioner or the director, would that vitiate the, would that validate the illegal proceedings?
Your Lordship, that at least, Your Lordship, that the Honorable Apex Court in 2 or 3 judgments has said, Your Lordship, in Madan Lal and then Sharana, Your Lordship. It is clearly said that once you participated, you cannot raise finger against the constitution of the
Would
selection.
she have known from beforehand what is the composition? If it was known from before, the process was otherwise also tainted. Making known the member, the composition of the committee before interviews, that by itself vitiates the process.
No, Your Lordship.
It
yes,
has to be a completely confidential
No,
process.
it's not required, but it is required that once you find that there are some illegality in the constitution of selection committee, then
Okay.
you will have to, Your Lordship.
Let a fresh,
raise your-
let a fresh.
Your Lordship will pass order, Your Lordship. I am relying on 2 or 3 judgments, Your
Yes,
Lordship. may
sure.
Record that, Your Lordship.
Yes.
That one is, Your Lordship, 1995 3 SCC 486, Modern Law, Your Lordship.
Yes.
There are 9 and 10, Your Lordship.
95,
95 3 SCC 486.
4.
4.
Yes.
486, Your Lordship. There are
Yes.
9 and 10, Your Lordship. Small paragraphs, Your Lordship. It is now well settled that if a candidate takes a calculated chance and appears at the interview, then only because the result of the interview is not palatable to him, he cannot turn around and subsequently contend that the process of interview was unfair or the selection committee was not properly constituted.
So whether there is an averment in this that the selection committee composition was contrary to the rules, let us know. Is there any such fact in this judgment? And then the most significant factor is, was there anything by which the candidate could know what would be the committee composed of?
So for that, Your Lordship, our High Court judgment, Your Lordship.
Yes,
I am
judgment is
relying
there.
upon, Your Lordship.
Division bench.
Division
What he
bench.
relies upon. Yes.
Yes.
Read.
division.
This is the judgment.
This is, Your Lordship.
Guwahati University.
I am, Your Lordship, relying on another judgment, Your Lordship, Recapital 323 of 2016, Your Lordship.
Yes.
Your Lordship, will find it.
Read.
Para 4, Your Lordship, may kindly read, Your Lordship.
Hmm.
Respondent number 6 then challenged the selection process on the ground that the selection committee was not properly constituted.
Hmm.
As required under Rule 84 of the said rules, in as much as instead of senior most graduate teacher of the school, the second senior most teacher is
Now,
included.
this judgment is contrary to the subsequent judgment by the same bench.
But, Your Lordship, here, Your Lordship, it is
Yes.
categorically stated, Your Lordship.
Yes.
And
But herein, Mr. Botakur, herein there is a serious allegation that there was one person who was not supposed to be there. His presence by itself creates a doubt.
Lordship, that doubt, Your Lordship, will have, Your Lordship, his doubt, Your Lordship, will have, Your Lordship, some meaning, Your Lordship. If he could have granted any award, any marks.
Then why he was there? Why he was there?
No, Your Lordship, that's what they have said, Your Lordship, that he was as a facilitator. And
No.
that's why he has not raised that
Facilitate
point.
what? Selection of some particular
No, Your
person?
The documents, etc. It has been a specific statement, Your Lordship.
The other members didn't require any clerical
There
assistance.
are clerical things to be done in the selection process, Your Lordship. Now, Your Lordship, that's why para 20 of the Honorable Single Judge judgment is important, Your Lordship, where very categorically, Your Lordship, there is a finding. by
This
the-
judgment holds as the senior most teacher recused himself, the inclusion of second senior most graduate teacher was proper and legal. That is entirely different on facts.
Then, Your Lordship,
Here the entire composition is bad.
para 10, Your Lordship, will kindly of this judgment, Your Lordship.
Yes.
Right to challenge the constitution of the selection committee at the fair end, being unsuccessful in the selection process is not going to the respondent number 6 in view of the settled position of law as held by Supreme Court in Dhananjay
Yes.
Malik versus.
All right.
so and so.
Mita Sai, subsequent judgment 2019, wherein every other earlier judgment was considered. That where the candidate alleges misconstruction of statutory rules, The same cannot be condoned only because the candidate has participated.
So that judgment is there, your lordship, and
Madan Lal has been considered.
other judgment are also there, your lordship.
You can't save
Number
the
of
situation,
judgments, your
sir.
lordship, which says, your
You
lordship.
just are not in a position to save the situation. The
And in
process,
fact, your lordship, in the, in 1976, 3 SCC, your lordship,
Mm,
that is another judgment I am relying on, 1976, 3 SCC 585.
yes.
Para 7, your lordship.
Mm,
One paragraph, small paragraph, your lordship, the High Court also held that appellant having submitted to the jurisdiction of the selection committee, he could not be permitted to turn around, denounce the constitution of the committee. That has been held. And
Is
para
there an
15
allegation of the constitution being contrary to rules? Read that judgment, please.
Yes.
Any case wherein the committee's composition was challenged
Yes.
as being contrary to the rules.
अपनी को- अपनों को- को-
Mm,
I am actually for the committee, my lord.
yes. This department says, yes, committee was contrary to rules. You just heard him.
I'm coming one thing, my lord. Your lordship kindly come to me, my lord. Face, my lord.
Saikia, you will have to wait for a while.
No problem, Lordship.
Yes. You hear the wonderful arguments which are coming. We benefited by those. Yes,
Yes, my lord. Your lordship.
reading at what page, please?
Para 15
Of,
of the judgment, my lord.
Yes.
120, my lord.
para 15, read
Yes,
please.
The so-and-so, I will counsel so-and-so, while controlling the submission of so-and-so, the contract with under counsel estimate, it is the as the namely constitution of election committee. In the instant that there is no vice principal. Because my lord, vice principal is the member of the committee, my vice principal is not available, my lord.
Yes.
The student, but the principal, the management, the faculty himself, being an assistant role, the member secretary was played by singing.
How could a subject teacher fulfill the requirement of vice principal, please?
No, subject teacher is the member of the committee.
Yes.
There was a notification.
There is a notification, my lord. And
Who,
there
who,
is a
who participated as the,
only thing is Rupak Deka has been appeared in the committee, my lord.
yes,
Vice president of the SDMC.
yes.
He was working as a my lord facilitator. He is not involved in the marketing process.
Let us see the minutes, whether it is mentioned that he is a facilitator. Let's see the minutes. Yes, please.
It is nowhere stated.
Where are the minutes, please?
Sixty-five, 66.
65. Yes.
My lordship,
So there are vitiated, the meeting was vitiated on two grounds. Role of member being played by the vice president and the member secretary being a subject teacher only.
Your lordship, that is your lordship as per the guideline issued by the director of second higher education. Your lordship. Since your lordship rule is silent, if the principal in charge is a candidate, your lordship, who will be the member secretary, your lordship? Since rule is silent on that, your lordship, there is a notification from the.
Assuming if we ignore that, what about the member?
Lordship.
There are three
Only
members.
That part, your lordship, the issue of member, your lordship.
So the issue of member remains. That is there. Yes.
lordship, can you go to the selection committee report?
Annexure?
Committee report.
This is from record, your lordship.
There are. Yes, my lord.
What report?
His signature is available, my lord.
The page 65, the report is there. Interview board.
Yes, my lord. Another thing is that my
We'll, all right, we'll continue it day after tomorrow. Third in part list on so and so for further hearing. Day after tomorrow. Okay. Yes, Miss.
Lordship, item number 23 and 24.
Yes.
These two matters, Lordship, relates to Madrasa TET. This matter can go to the education bench, which Lordship is proposing to constitute.
These pertain to
Education Department, MTET, Madrasa TET.
My lord, I am appearing.
provincialization,
No, no, my lord, this is a purely, my lord.
Recruitment.
recruitment. So you want it to be posted before?
The education bench, which Lordship is proposing.
No, that
to
is only
constitute-
for provincialization, only
Okay,
related
perfect.
to provincialization.
No issues there, no issues.
Only
Item,
provincialization.
yes, item 26, Lordship.
Yes.
In that case, I am appealing for the appellant Sebi.
Mhm.
Dear Lordship, on the last occasion before the writ court, certain
Yes.
records were produced on the basis of which an opinion was formed by the learned single judge.
Mhm.
Those records, I would like to place it through a affidavit.
Okay, file it, please. Do that.
Let the matter come up on 28th or 22nd.
Ms. Saikia, appearing for the appellant Sebi, submits that he is desirous of bringing on record certain additional documents from the original record by way of through an affidavit. Who is
I am
appearing?
appearing for sole respondent, your lordship. The lordship may take up this matter after 22nd, your lordship.
He is permitted to do so. The requisite documents, affidavit with the documents be filed within next 10 days.
Lordship.
Miss 10 days, re-notify. Then counsel who is appearing for the respondent, he says that it may be taken up after 22nd. So let it go, then it goes to July, Mr. Saikia.
After vacation,
I have no objection.
List in the last week of July.
Highly obliged.
Lordships, with the lordship's indulgence, may I pray for a fixed date in the item number 21 of the lordship's list, the next matter.
21, then it,
My
madam,
learned
any
friend,
date in July now.
The learned advocate general also appears in this matter subject.
July,
to his-
July, whatever date you want,
to
July.
lordships, June, any date, your lordships, any date subject to your lordship's convenience.
All right, this is-
Any date, your lordship.
Ms. Saikia, when do you, when madam says
Let
that?
it, then let it be on 20/28, 20.
20, okay,
I'm deeply obliged to your lordship.
20th June,
My lord, item number 27 and 28.
yes.
And a short date may be given, madam.
Date, any date you take in July, sir. Ask the court master, he will give the dates.
lordship, can it be on, I am for item number 20.
Now mention to the court master, take any convenient date in July.
Lordship,
Thank
there is
you.
an, lordship, there is an interim order in item number 28. Interim order in item.
Interim order shall continue.
Much obliged.